have been before the court before in order to do things. This is how we check on it to see if you're actually doing what you were ordered to do. So when your name's called, we got several people on teleconference. If you're on teleconference, speak up when your name gets called. If you're here in person, come up to the table to your right, stand there. We're going to review your file. If you have new cases, and we've got a few new cases we're going to get to after we do the reviews, I'll have some more instructions for you before we start this. So call the reviews, please.
Charlie Atkins, Tasha Atkins, Jeremy Caldwell, Betty Martin, Edith Gregory, Adam Reimer, Timothy Sanders.
Charlie Atkins is 2588 case number. He hasn't done anything on his case. Is Charlie Atkins here?
He's on Zoom.
All right, so I see Tasha and Charlie Atkins' name, and she has a case too. I'm not showing that either one of you have done anything on your cases. Is that all right?
We've been doing community service to Adelia. He was gonna email in.
Your Honor, they called and asked to do community service at Athalia. I did talk to Willie Ward, and it was approved, but I have no proof that they've done anything yet.
Okay, well, you need to get that in, have them send it in to the court so we can get you credit for it. What about your fines? What are you gonna do on that?
I have a little bit of money. I have like $20 a piece to pay on today. I just have to wait until my ride can get off Breezy Ridge.
Well, you can pay it online. Do you have access to a smartphone or a computer?
Okay, I can do that.
Okay. Everybody's got a smartphone now. I don't think I've asked anybody if do you have a smartphone? Anybody said, no, I don't have one. So, we have a website, Lawrence County Municipal Court. Google it. I know you know how to Google. Google it. The website will come up. There's a place on the website to pay. There's all kinds of stuff you can get there. Because I'll have people say, I didn't know what I was supposed to do. I didn't know when I was supposed to come back to court. There's no excuse because it's all on the website. You can put your name in the record search, pull your case up and see what you're supposed to do, when you're supposed to do it. That excuse does not fly. So, get your hours in here. If you don't get any hours in, then you're going to have to start coming in person rather than coming by teleconference. Are you living in Athalia? Where do you live now?
Adelia.
Okay. I'll give you another date for your next this is your first review today.
Yes, sir.
Okay, so I'll give you another date. And as long as you're making progress on your case, I'll let you appear by teleconference. So let's go to the end of January next. I've got a schedule. I've got to get that up on the screen. January 30th will be your next hearing.
Okay.
That's the last Friday of January, 9 o'clock for both of you. Okay, that's all.
Thank you.
You're welcome. Jeremy Caldwell is here in person. It's 25338. It's his case number. And he's got a report. You've done all your community service. That's good. It's a very good report.
Thank you.
Mr. Caldwell, so good job on that. And you made a payment at the beginning of the month, December 1st. Okay. Keep up the good work. I'm going to set you, so yours is still a 25 case, so I'll set you for the 23rd of January. next year, January 23rd, 9 o'clock. Keep doing what you're doing.
Thank you.
You're welcome. Betty Garton, 14943. Betty Garton here, or on teleconference? I don't see that. Case number is 14943. It's been called. She did pay her fine off, but she hasn't done any community service.
Your Honor, I have a note that Ms. Gardner was ordered on 11/7 to have some community service done before today, and she's not done any.
Okay. Well, let's see, she may have a bond up.
She's just under review on it.
Yeah, well, sometimes it mistakenly gets reviewed, it should have been under sentencing. I had a note on the front of the file about a bond. Maybe it got changed to an OR at some point, but I don't see, there's not a bond in the file.
I don't see anything on the hard.
Okay, so I'll issue a warrant for her for failure to appear today for her review. Edith Gregory, 25315.
Your Honor, they called this morning, they're coming from Columbus, they said they was 2.5 hours out, and they was leaving at 7:45 this morning.
Okay. We'll recall it later in the docket. She was
She
supposed to
did,
have counseling at RRS.
Yes, Your Honor. She completed anger management with us. She quit coming to services due to moving to Columbus.
Okay. I'll recall her later in the docket to see if she does show up. Adam Reimer, 22327. He has been at the counseling center. Is he on?
He
Adam
is,
Reimer?
Yeah, he's at large.
Okay.
Yeah.
He left on November 24th against staff advice. Okay. He had other stuff to do, fines and community service, he hadn't done any of that, so. And he left treatment that he was ordered to do, so he gets a warrant.
Thank you, Your Honor.
Thank you, Mr. Turbin. Timothy Sanders, 2584. He's at RRS.
Do you have community service or anything?
Okay, it sounds like from the report you're on the right track now, but we might have had.
Your Honor, he had a recent setback, yeah.
Okay. All right, so I want you to continue on with your counseling with RRS. Do you think it's helping you?
Yeah.
Okay, let's keep doing it. You paid your fines off, so that's all you need to do. I'll set you for January 30th also. Next month.
Thank you.
30, 26.
Thank you, Your Honor.
You're welcome. Okay, that finishes the review, so now we're going to start the arraignments. Arraignments are what lawyers call the first hearing on a criminal case. The purpose of an arraignment is to tell you what the charge is, what your rights are, take a plea if it's a misdemeanor, set a new hearing. So when you're called, just like the last people, when your name's called, come up to the table to your right, stand there, I'm going to go over the charge with you. You don't have to agree with the charge, but you need to understand it. I don't decide what charges are filed against you. Usually I don't see them until they're right here when your name's called, and I'm going to look at it and read it. I usually don't know anything about the charge, but you need to understand it. It may be totally false. But today's not the trial. A lot of times people want to get up and immediately start, Judge, this is what really happened, blah, 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 blah. Today's not the trial. So what you're saying is going on the record. That's one of the things you need to understand. I know probably none of you are lawyers, but on the record means it's going against you, it could be used against you, what you say in open court. Everything we do here is not only now that we record it. When I first started, we just recorded it. We didn't video it. Now we video and record it. So if you get up and say, I did X, Y, and Z, there's going to be a video of you saying that the prosecutor can use against you later if they want to. So it doesn't do any good to get up and tell me a whole bunch of stuff about what happened, unless you're going to plead guilty and you want to do an explanation. But if you want to talk to a lawyer, if you want to have a trial, or if you don't know what to do, you should enter a not guilty plea, and then don't tell me a bunch of stuff about what happened, because it can be used against you. You have a right to have an attorney. You have a right to have an attorney appointed if you can't afford one. And I'll have to ask you about your finances if you want one appointed. You have a right to bail, and you have a right to make the state of Ohio prove any allegation they make against you in a charge beyond a reasonable doubt. That's the highest standard of proof in any type of case. So, sometimes people get up here and they say, I just want to get it over with, I'm entering a guilty plea. That's not a reason to enter a guilty plea, getting it over with. That's not what the court is here to do, just get stuff over with. We're here to do justice. So if you feel like you're wrongfully charged, then you need to enter a not guilty plea and talk to a lawyer. Call the first case.
State of Ohio versus Hayden Curry, case number TRC 25-004, A and B.
Sir, you Hayden Jack Curry.
Yes, sir.
Mr. Curry, it's alleged on December the 7th of this year at 2:08 a.m. in Union Township, you were driving a vehicle while you were under the influence of either alcohol, drugs, or some combination of those things. The state's alleging that you refused to take any tests. The state's also alleging this would be your first conviction if you get convicted, so that makes a difference as to the penalties. The penalties go up the more convictions you have. So on a first offense, the maximum you face is 6 months in jail, a $1,075 fine, and a 3-year license suspension. That's the most that the court can impose if you're found guilty. There is a minimum, and that means I can't go below 3 days in a treatment program, $375 fine, and a 6-month license suspension if you're found guilty. You understand the possible penalties in that charge?
Yes, sir.
Then you're also charged with driving without a driver's license. That's what's called an unclassified misdemeanor. It carries no jail time, but it carries a maximum penalty of 500 hours of community service and a $1,000 fine. That's the most you can receive on that charge. You understand the two charges?
Yes, sir.
I explained the rights that all defendants have right before we started. Do you understand that?
Yes, sir.
Do you have any questions about your rights?
No, sir.
How do you wish to plead to these charges?
Guilty.
Guilty means you're admitting that these charges are true and waiving the right to have a lawyer and a trial and to make the state prove the charges. They're not going to have to prove the charges because you're admitting it's true. You understand that?
Yes, sir.
Is that what you want to do?
Yes, sir.
Okay. I'll accept your guilty plea. I'm going to read, the officer wrote a report to the court called an impaired driver report. So I'm going to read that into the record. I've never seen it before. So I'll read it into the record, and that's what I'm going to consider as in terms of sentencing, what I need to do on sentencing. You have a right to make a statement too. After you hear this, then if you want to make an explanation or statement, you can. You're not required to, but you have the right to do so. Okay, so this is from Trooper Jewell, is the arresting officer, Christopher Jewell. He says, November 7th, 2:08 a.m., Lawrence County Sheriff's Office advised there was a single vehicle accident on County Road 123A, Union Township, and requested assistance from the OSP, and said they also had a possibly impaired driver. Trooper Beam responded to the scene. The Sheriff's Office advised the driver had been located On Trooper Beam's arrival, he requested I respond as well. I arrived at 2:32 a.m., made contact with the two deputies and Trooper Beam, who was going to administer field sobriety tests. Deputies advised they had received multiple reckless operation calls, 2 reports of a vehicle near the boat docks doing donuts. The call was subsequently received Sheriff's Office of a crash. Deputy Cochran informed me that they had a second possibly impaired driver at the scene who did not have a license. I confirmed with Deputy Cochran that the driver, Hayden Jack Curry, admitted to driving. I approached him and made contact with Mr. Curry. I asked him what occurred. He admitted that his buddy and he did donuts down the boat dock, and when he came back to the house, his buddy got a hold of him to let him know that he crashed his vehicle. Mr. Curry advised that he pulled his buddy out of the ditch and returned to the house. Immediately upon returning and parking in front of the residence, the deputy was pulling up to the house. While speaking with Mr. Curry, I observed that his eyes were bloodshot and watery. Also detected odor of alcohol coming from his breath and person. Asked him how much he had to drink, and he admitted to having a few shots. Asked him how many was a few shots, he said about 4. Asked him how old he was, he said he was 20 years old. Asked him if he had a license, he said he did not have a license. Asked him to perform tests for impairment. Once in front of the patrol car, asked him if he had any injuries to his head or any ear infections. He said he did not. That he had had an ear infection 2 to 3 weeks ago. He had taken the antibiotics for. Asked him if he had any fluid issues in the ears. He said he did not. I asked him if he could walk a straight line and keep his balance. He nodded his head that he could. Asked him about medications. He said he was not taking any medications. I gave him horizontal gaze and nystagmus test, which is the eye test for alcohol, and there were 6 clues for alcohol, which is the most you can have, 6 of 6. Gave him walk and turn test. There was 2 clues for alcohol on that. Also 2 clues on the one-leg stand test. Gave him a portable breath test, and it showed a result of .09. He was placed under arrest for operating under the influence. Gave him his Miranda rights. He was transported to the patrol post. Offered him a urine test, and he refused to provide a urine test. He was charged with operating under the influence and operating the vehicle without a valid license. Okay. Anything you want to say?
No, sir.
Why haven't you had a license?
I was working on getting my license, and then I got pulled over one day going to work, and they suspended him, so I haven't had him since then.
Okay. Was that in West Virginia?
Yes, sir.
Because at one point you had a Wayne, West Virginia address.
Yes, sir.
Is that where you're from originally?
Yes, sir.
Did you ever take the test?
What test?
Driver's test.
Oh.
Driver's, to get a driver's license.
I had my learner's permit, and like I said, I got caught driving to work one day, and they suspended it.
Okay. Well, you don't have to respond to this, but it's like, it stumps me every time. Of course, I'm old, but when I was 16, everybody, and I mean all my friends, everybody, the instant we could get a driver's license, we were there getting our driver's license. Now I see it all the time. People don't get their driver's license, you know, you're 20, you know, never had a driver's license. That just did not happen back in the day. Everybody wanted a driver's license because it was freedom, way to get out and get around. So, you need to get your driver's license, and this is going to make it harder. This is going to make it harder for you to get your driver's license. Eventually, it'll clear up. You'll be able to get your driver's license, but you just keep digging the hole deeper. Every time you get something like this on your record, then it's gonna take longer and cost more money. And it's gonna cost more, because you gotta have insurance now when you get your driver's license. And your young male with a conviction for OVI, sky-high insurance rates. I mean, that's just the way it is.
Deputy clerk indicated there are more charges coming.
Oh, okay.
Just learned that.
Well, sounds like there's gonna be some more charges coming. I just was informed by one of the clerks that there's gonna be some more charges. So I'm gonna order you not to depart the courthouse. They're working on the charges out in the clerk's office now. They'll bring them out when they're ready, and then I'll have the bailiff call you back up and we'll finish whatever charge. I don't know what they are, but there's some other charges that are following against you. So have a seat, you'll be recalled.
Yes, sir.
State of Ohio versus Misty Jane Crick, case number CRB 18740. Your Honor, I believe she's on Zoom.
Okay. All right, and ma'am, you're Misty Jane Crick?
Yes, sir.
Okay, which one is Misty Jane Crick? I'm not seeing it. We've got several people on the teleconference today. So. Oh, I see it now. I had to blow it. I had the little tiny screen on my laptop, so now I can see it. All right, this is case number 18740. It was a theft offense,
She's appearing on a bench warrant.
and there's a warrant outstanding. It looks like you had failed to appear for a review hearing back in 23, October 27th of 23. And we got an email from you, or some contact from you asking to get this cleared up. And then you're in are you in a facility called Serenity Hills?
Yes, sir, I was. I did 3 months there. I just completed it last Friday, and now I'm in a 6-month program at the WIN program in Wheeling, West Virginia.
Okay. So what I'm going to do, I'll withdraw the warrant. You had a warrant outstanding, and I'll withdraw that. You'd done your community service, you just hadn't finished paying your fine. So I'll withdraw the warrant. Are you able to work now, or are you in a program where you are not able to work yet?
I have a 30-day restriction, and then after my restriction, I can get my phone, and then I can get a job.
Okay.
But I should have my cash app sometime next week, so I can try to put probably like $10 on it Friday on the.
Okay, that would be good. What I'm going to do, I'm going to go a couple of months out for your next hearing to give you a chance to get settled in there, hopefully get a job. And look, I'm supportive of you getting in recovery. I want you to do well. I want you to finish the program. I want you to take care of this too. You know, getting in treatment is not a get out of all the prior stuff that I ever did in my life card. You still have to take care of what you did in the past, but I'll work with you to get this done. Hopefully you'll get in recovery, stay in recovery, get a job. As long as you're making progress toward that end, I'm going to work with you.
Thank you.
So because you've contacted us and showed up, I'm withdrawing the warrant that had been outstanding for you all this time. I'll set a new review hearing for you. Let's go 2 months out, so that's February the 13th, the second Friday in February. And as long as you're making progress, you can appear by teleconference like you are today. And that's going to be at 9 a.m. on February the 13th. Okay, do you have any questions? And what I'm showing you owe, $195 is what I'm...
How much, Your Honor?
The clerk is correct, because there's probably a warrant fee on top of this. Your fines were $195 that you hadn't paid, but you got to, if somebody doesn't show up, we have to issue, the clerk issues a warrant. It goes to the sheriff. They issue it to all the police agencies all over. So there's some work. It's more than $50 worth, but we do charge $50 for doing a warrant for somebody. So you got a warrant fee on top of the $195, so it's 235 or
Gets you on to
235 is what you right now. So just make whatever payments you can on it, eventually get it done. And if you can't pay anything, if you do extra community service, for every 6 hours of community service you do, I'll give you $50 credit for it. So you can do that
I
too.
do community service here, Your Honor. I work about 20 hours and,
Well, we don't let you do it at the treatment facility where you're at. It would have to be at a charitable organization in the community.
I don't do it at the facility, I go outside the facility to do it.
Okay, we'll get us something on the letterhead, submit it, and we'll take a look at it.
Okay, and what email would I send that to, Your Honor?
Why don't you call the probation department, and they'll give you an email. Or you can look, I don't know, is it on our website, does it have the email addresses on? If you look at our website, I think it's got the email addresses on it.
Yeah, I'm going to do that, Your Honor.
Okay, February 13th, your next hearing, good luck.
Thank you.
You're welcome.
State of Ohio versus Joshua Harris, case number CRB 25741.
Sir, are you Joshua Harris?
Yes, sir.
Mr. Harris, it's alleged that at Rome Township on November 12th of this year, you engaged in a pattern of conduct knowingly that caused Courtney Beater to have mental distress to themselves or a household member, that you would cause physical harm to Courtney Beater or a member of her family or household. The charge is menacing by stalking. It's a first-degree misdemeanor. Maximum penalty 6 months in jail with $1,000 fine. Do you understand this charge?
Yes, sir.
Do you understand the rights defendants have in criminal cases?
Yes, sir.
Do you have any questions for you in our plea?
Yes, sir.
What plea do you wish to enter?
Not guilty.
Do you want a lawyer appointed to represent you?
Yes, sir.
Do you have a job?
Well, it's seasonal, wintertime, no. I run landscaping, so I would need one appointed.
What's your, I have to determine your gross annual income. Do you know do you file an income tax return?
No, I haven't I just started at summertime, so I haven't done anything really yet. So basically, I'm not working, let's just say that. I have no income.
Do you have any money saved?
Yeah, a little.
Okay, tell me about that.
I just save money at home. I do little side jobs,
Well, tell me how much you got.
$400 or $500.
And you have no income.
No, sir.
Your Honor, the computer showing he also has a warrant. I don't know, do you have that, CRB 21583?
I do not.
They said that when I had court on the 4th in Lawrence County, they dropped that. That was a domestic violence through my sister, and she dropped that.
Okay. We're going to pull that file, so we'll recall you. I don't have it in front of me, so just have a seat. We'll call. I don't have the papers. We'll recall it.
Okay.
State of Ohio versus Brian Martin, case number TRC 253015, A, B, and C.
Are we allowed to go out for a second? So are you Brian Keith Martin?
Yes, sir.
All right, Mr. Martin, your case number is 253015, and the state is alleging that you committed an operating a vehicle under the influence charge on December the 6th of this year at 12:53 a.m. in Perry Township. The state's alleging that you were operating a vehicle under the influence of either alcohol, drugs, or a combination of those things, and that this would be your first conviction.
Yes.
On a first offense, the maximum you face is 6 months in jail, $1,075 fine, and 3-year license suspension. The minimum you face is 3 days in a treatment program, $375 fine, and a 6-month license suspension. State's alleging that you submitted to a urine test. The urine tests go to a lab in Columbus for testing, and it takes a while. I don't have any results now as to what the state's going to allege was in your urine. Eventually, we will get those back, but it takes quite a while to get the results back. The other charges that you face, failure to control your vehicle, that's a minor misdemeanor, maximum penalty is $150 fine. And driving an unsafe vehicle, also a minor misdemeanor, maximum penalty is $150 fine. So you've got 3 charges. Do you understand the 3 charges?
Yes, sir.
Do you understand the rights you have as a defendant?
Yes, sir.
How do you plead to these charges?
Not guilty.
You want a lawyer appointed to represent you.
Yes, sir.
Are you working?
Yes, sir.
What do you do?
Auto collision.
Auto collision, is what you said? Are you paid by the hour in your job?
Yes.
How much per hour?
I think it rounds up to like $16 an hour.
How many hours a week do you work?
40.
Do you have any dependents?
My son and my ex, yeah.
Okay, and you're supporting your son by some sort of means?
Huh?
You're paying child support or doing something to support your son?
Yes, we don't do child support, but I pay for my son, yes.
All right, you're eligible. I'll appoint Mr. Smith to represent you. Not guilty plea is entered. There's a urine screen here, so we're gonna have to go out a ways before that's gonna be back.
Judge, I'm here the 23rd or 26th of January, maybe we can see if it's back.
Well, that's probably gonna be longer.
I can go
How
further,
about February?
until February.
February 6th?
Let's see. That's a Friday, yes, sir. I can do
February
it.
6th, okay. I'm gonna set the next hearing for February 6th. 26th. And that'll be a pretrial at 10 a.m. Mr. Martin can sign a $1,500 signature bond. So what this means, Mr. Martin, you're just signing a piece of paper that says, I promise I'll come to court when I'm ordered to. And if I don't do it, I'm going to pay $1,500 as a penalty. Plus you get a warrant for your arrest for not showing up. So that's the worst part. But if you come to court, you don't have to post any money.
We need to be fingerprinted,
He
John.
will need to be fingerprinted, so it's a fairly new thing. So, Mr. Cooper's gonna bring you a piece of paper, you gotta take it to the jail and turn it into them, and they will fingerprint you and let you go. You don't have to stay there, you gotta get your fingerprint.
Call you before this?
Yeah, call me, ask me for Sam, here's my information, ask for something. He's my legal assistant, get you to talk about the case for the 6th. Just have a seat in the lobby, they'll get you a card, you gotta get fingerprints. Just have a seat in the fingerprints.
Your Honor, that's all you
Okay, that finishes the arraignments we have. I think we got more in the works. They bring some in the mornings, and they got to process the paperwork, and it's not done yet. So we'll get, you were told to be here, and I know there are some that are being recalled. Don't leave, you stay, and we'll get to you as the paperwork's brought out. We're going to start some of the pre-trials that are set for today, so we need the lawyers and their clients that have pre-trials on the docket to be in the courtroom now.
State of Ohio versus James Garrett Adams, case number CRA 25732, CRB 25138, CRB 24130.
One of these is an arraignment, it looks like.
Yes, sir.
All right, this is Mr. Nash's case, and it looks like there's a new charge. I don't know if you're aware of that.
Today I found out.
Bailiff just gave you a copy of it. Do you want me to read that in the record, or
No, Judge.
you waive that?
We do.
John?
So how does that, how do we want to proceed then, now that we've got a new charge?
I've spoke with the prosecutor. Mr. Adams is in the process of cleaning up his property. It's not fully complete, but he needs to finish it. We're asking if we can reset that on January the 23rd. And if there's a time waiver that's needed, he'll do it. And we'll do it orally here in court as well.
Well, part of our effort to kill more trees, Mr. Heald always has a written waiver
That's true.
that he wants signed. And that came after a Court of Appeals decision that
We'll do one.
didn't like some of our oral stuff, so. So,
We
Mr.
killed a
Hill,
lot of trees doing this. too,
Yes.
by the way.
they have to pay the price. What's your position? He wants to continue this to January 23rd, I believe you said?
Correct, Your Honor.
We're not opposed to that, Your Honor. And we just provided some new discovery to Mr. Nash today in the proceeding, the case that was here previously. So we want to give him an opportunity to review that stuff too.
All right, so we're going to, because there's several things pending, and I'm going to continue all of them. Some are pretrials. This new one's going to be a preliminary hearing. January 23rd of next year for preliminary hearings and pretrials at 10 o'clock. Looks like there is a bond up on the, some of the previous things, so since he's appeared today, I'll allow him to sign a no-R bond
Thank you, Judge.
on the new charge of $2,500. I think he's gonna have to go under this new policy that we have. You'll have to go get fingerprinted again, I believe,
Oh, okay.
on every case they want.
Sheriff's Office?
Yes.
Okay.
So Mr. Cooper will give him a form to take to the sheriff. Then we'll be coming back on the 23rd of January for all hearings
Okay. Did they
in
get
this
this?
matter.
Did they get this record to-
January 23rd, 10 o'clock.
Thank you, Judge.
Right.
I'll have Mr. Adams wait out in the lobby for the paperwork.
Yes.
Okay, thank you.
Thank you.
What date?
State of Ohio versus Aristides Alexandropoulos, case number PRC 25-27-44.
Okay, Mr. Haslam is here in person, so is the
Your Honor, the state and defendant have reached an agreement in this case in exchange for dismissal of all the charges except for the OVI. The OVI will be amended to a first offense, regular test OVI. Mr. Alexandropoulos will plead guilty to that and complete the 3-day dip course. The firearm that was taken from him during the stop will be returned to him.
Mr. Hill.
Your Honor, with respect to the gun, he has a job which requires him to, I guess, carry money and things of that nature, and that's the reason he has the firearm. We got the urine result back for the alcohol, and it tested .213. So it was not a high score, but it was above the minimum per se. And so we're okay with, if the court is, of course, with the return of the weapon. I told Mr. Haslam that he needs probably to do an entry on that unless.
Is that the sheriff's office or OSP? Do you know?
OSP, Your Honor.
If you would, please prepare an entry that'll direct them to return it to him. He is the owner.
Yes, Your Honor.
So he'll need to get a certified copy from the clerk and take it to the post to get it returned to him.
Yes, Your Honor.
And so we are okay with also dismissal of the marked lanes and the safety belt upon the plea to the OVI, and our request is for the mandatory minimums on the OVI.
Okay. All right, sir, you have a right to make a statement if you want to. You're not required to. Do you have anything you want to say?
No, sir.
And Mr. Hassan, anything you wish to say?
No, Your Honor.
Okay, so 25 CRA 690 is dismissed, as are TRC 25, 2744 B and C. There's a plea of guilty to the A case, is that correct?
Correct, Your Honor, to the OVI.
So we'll go sentencing on that. I'll impose a $375 fine, where the cost be paid. License suspension will be 6 months, and that starts today. There was not an automatic license suspension in this case. 30 hours of community service, 2 years of level 4 probation. Jail is suspended. He's to attend and complete the driver intervention program. The firearm that was taken by OSP is to be returned to defendant. There'll be a separate entry specifically directed to that, and you'll need to put in some description if you have that, or if you don't, there probably is, I haven't looked, probably some description in the file as to the weapon involved. They'll need a description of it. His review hearing then would be July 6th of next year at 9 a.m.
Your Honor, the only question I would have is with respect to the 6-month license suspension, because he does drive for work, and we have the dual problem, as the court is aware, of Mr. Alexandropoulos being a West Virginia resident. West Virginia is obviously going to take extreme steps with respect to the license. We would ask that he be permitted to at least drive for work, and the West Virginia issue with the license suspension is going to be a quagmire and a nightmare to resolve anyway. So if there's any way we could work on the license suspension here.
Yeah, he can have, he can actually have unlimited driving privileges as far as I'm concerned, but he has to then put the blow-and-go device on his vehicle.
And he plans to do that, Your Honor.
Okay, so just talk to Mr. Major when he meets with him. The closest facility that supplies that is out of Portsmouth, so he can make the arrangements there, have a place, and then get unlimited driving privileges. And we'll need an order from the court granting that. And we've never had a problem in West Virginia, but in Kentucky, we have had some courts that say, we don't care what the court in Ohio says about that. That's pretty rare, but just be advised that it's going to show up on your driver's license as if somebody checks the computer that you're suspended, then you're going to have this piece of paper from me saying, oh yeah, he can drive if he's got this device. The other thing, if you don't want to place the device, I can give you limited driving for work, some other things, but not unlimited. So you got to prove then if you get stopped, I'm out doing what I'm supposed to be doing in the time frame I'm supposed to be doing.
And Your Honor, he's already received the interlock letter from the West Virginia DMV.
Okay.
So I'm not sure what the court's preference is if he completes the interlock through West Virginia and provides proof to the
That's
court.
fine.
Okay.
They'll require, from my experience too, I'm ordering him to do the 3-day school. They'll accept that, but they will require him to go to some kind of program themselves independently. But they do accept the Ohio. I'm requiring, I have to require it in Ohio for a first offense. So he'll need it for both states, really.
Yes, sir.
You need to get that done, and Mr. Major can help you. You don't have to go, there is one here in Lawrence County, you don't have to go to this one. You can go to it if you want to. It's more expensive than some of the others. I know the one in Chillicothe is like $200 less. I don't know if it's worth to drive to Chillicothe for $200, but anyone that's approved by the state of Ohio, you can go to.
Okay.
If you go to the one here, I know they'll file paperwork with the court that shows you've been there. If you go to one in Cleveland, I don't know what they'll do. So
Yeah.
it's a different state. It's the state of Cuyahoga. So, any questions, sir?
No, sir.
You'll need to see the probation officer, and then you're free to go after that. And his review hearing is July 6th of next year. It gives you a lot of time to get it done. You should get it done. If you have, you don't have to show up. If you don't get it done, you need to show up and explain why and ask for more time. If you blow it off, that's where you can go to jail. Just blow it off and don't show up, and we have plenty of people do that, then they get a warrant. So just take care of it, and never have to go to jail.
Yes, sir.
Okay. See Mr. Major, you're free to go.
What court are you in?
July 6th, but I'll give you all that. Wait, just out front.
Good to see you, Mr. Haslam. Don't be a stranger. You've been a stranger for quite a while.
Your Honor, that's Mr. Smith's fault.
Okay.
Probably is. State of Ohio versus Jacob Lee Lindsay. Case number 25788, A, B, and C. Jacob Lindsay.
This is case number 25788, A, B, and C. Jacob Lee Lindsay. Jacob Lee Lindsay here. I don't have any proof of service on file. It's a summons, but it doesn't say it's been served. So at this point, I'm going to pass it for service.
State of Ohio versus Hayden Curry on a recall, case number TRC 25-2004 AMD, and case number CRB 25-789.
All right, so this is a recall on Mr. Curry. Mr. Curry, I have another charge on you now. It's criminal damaging is the charge. The bail's bringing you a copy of it. And the basis of this charge is, it's the same date as the OBI event, but it states alleging in this charge that on December 7th, 2025, you knowingly caused or created substantial risk to property at the Sims Creek boat ramp, and that you didn't have the right to do that. So that's criminal damaging, second-degree misdemeanor, maximum penalty is 90 days in jail, $750 fine. You understand the charge?
Yes, sir.
And you had told me before you understood your rights. Now, I didn't know this charge was coming, and you didn't either when you entered your plea to the other charges. So if you want to withdraw them, it was uncounseled, you didn't have a lawyer. If you want to withdraw your guilty plea, I'll allow you to. How do you want to proceed, sir?
I'll just plead guilty, sir.
Okay, so you want to plead guilty to the previous charges, which were no driver's license and operating a vehicle intoxicated, and now you got a charge of criminal damaging. And as I understand, you want to plead guilty to that also?
Yes, sir.
Okay. I'll accept your guilty plea, and there's an affidavit signed by a Deputy Cochran with regard to this charge of criminal damaging. So I'm going to read that into the record, and then if you want to make a statement or explanation about that, you can. Deputy Cochran says, on December 7th, I was dispatched to the boat ramp at Sims Creek for reports about reckless operation of a motor vehicle. Calls were originating around 12:05 a.m. I made a trip out there. There was no contact made with any individuals at the boat ramp, but there was damage could be observed to the grass and embankments around the boat ramps in Chesapeake. Caller stated that they observed two vehicles doing donuts in the grassy area of the boat ramp and operating their vehicles in a reckless fashion. However, when I got there, there was no one there. Then on the same day at 1:41 a.m., there was a second call placed into dispatch that was similar to the previous one, saying there was reckless operation of motor vehicles located in the same boat docks area. This was a different caller, stating that they were two SUV type vehicles doing donuts in the grass located around the boat ramps. And then there was a third call from Tracy, the person I guess identified themselves as Tracy Henson, who lived near the boat ramp. Deputies responded again. There was debris in the area from spinning tires. Deputies traveled a little further out Township Road 123 and located a vehicle that had lost control leaving Township Road 123, struck a mailbox, went on the opposite side of the road and off the road towards Sims Creek. I'm familiar with Township Road 23 through prior calls and knew that the road travels a little further out into the dead-end neighborhood. I was able to locate two Jeep Cherokees in the driveway with fresh dirt and mud all over the bodies of the vehicles. While I was pulling up, I observed one male standing in the driveway looking at a Jeep. As I was driving closer, I was able to see a second male in a black t-shirt running away from the driveway through an open garage door and an open breezeway exiting the house in the back. I called the first male to me, and he identified himself as Anthony Bailey of Huntington, West Virginia. During my contact with Anthony Bailey, he advised that he was the driver of the 2004 Grand Cherokee. They were in fact doing donuts in the boat ramp area. And he advised that when they left the area, was traveling on Chancellor Road 23, lost control of his Jeep, going off the edge of the road, struck a mailbox, and slid over the embankment. He called his friend Hayden Curry, who was just in front of him a short distance. Curry returned to the crash site and used a ratchet strap to pull the Grand Cherokee out and freed up both vehicles. Asked him if he had been drinking any tonight because I was able to throw a red glass of ice and could smell odor of alcohol coming from the person. He admitted to have been drinking prior to the accident, prior to doing the property damage at the boat ramp. I advised the homeowner that I needed to speak with the other driver of the white Jeep who had taken off on foot and believed he was still on the property. And he went and retrieved Hayden Curry from the house to come speak with me after discussing what was found at the boat. I was with him, talking to him about his vehicle, asking about the property damage. He admitted to going down there and doing donuts, causing property damage as well. When I was speaking to Hayden, I noticed an odor of alcohol coming from his person. Lawrence County Sheriff's Department turned the crash over to the State Highway Patrol for investigation and potential OVI charges. Okay, that's pretty much it. Okay, anything you wish to say, Mr. Curry?
Just ask you to have some mercy on me, Judge. I made a stupid mistake. It won't happen again.
Okay. Tell me about what, you said you worked, what do you do?
I lay blacktop for asphalt contractors in Lavalette, West Virginia.
And did somebody haul you to work, or how do you get back and forth to work when you don't have a
My
job?
girlfriend drives me to work.
Okay. Is she here today?
Yes, sir.
Okay, where is she? Okay. All right, well, this is a stupid young male, let's say. You get a few of those. Sometimes, you know, stuff comes, you get away with a lot of stuff, and sometimes it comes back to bite you. This is one that bit you pretty good. So, I think some community service and, Mr. Cooper, you need to get out there and scope out the boat ramp and see how bad this is. You know.
Your Honor, I've got pictures somewhere.
Oh, okay, good. Let's see the pictures.
Looks like it's grass turned to mud.
Yeah, it looks like a plowed field now. So I'd say some community service out there. I don't know when we can get it done, because it's probably might be frozen now, but you need to get out there and rake that out, maybe plant some grass seed and put some straw down.
Yes, sir.
Get it looking like it should. You know, a lot of people go there and hang out and fish and different things, and it's just, I'll agree with your characterization as stupid. Stupid young male stuff. So, how old are you, girlfriend? 19, okay. That's part of what young males need, is a female telling them what to do. Because I don't really see, I've been doing this over 30 years. I can't think of one time where I've seen a female out doing donuts.
Your Honor, she did tell me.
Okay. So if you listen to what she tells you, you'll be a lot better off.
Yes, sir.
So you have the right to tell him, don't do this stupid stuff. If he doesn't do it, then, you know, he doesn't pay attention to you, that's his fault, and you can take appropriate action. Okay, anything else you want to tell him?
No, sir.
Okay, on the criminal damaging, I'm going to impose a $200 fine. Where you pay the court costs, there'll just be one court cost when it's all happening. One court cost for everything. Let's do 20 days in jail, and I'm going to suspend all of it. Okay. So you don't have to go to jail, as long as you do the other stuff I'm going to tell you to do. I want you to do 5 days of community service. I want him on Sunday's community service out there cleaning up the mess he made with the boat dock. Mr. Cooper's in charge of community service. You'll work with him. So what's your work schedule?
I'm laid off for the winter, sir, so.
Okay, so you can get out here anytime.
Right
Now,
after
are you
this.
living in Chesapeake now?
Yes, sir.
Okay, so transportation's no issue. You're close by.
I can walk there, sir.
Yeah, okay, that's the right answer. I just was it Monday or last week where I had a guy that had community service, and he was about your age, young, fit, able to, and he said, I can't get there because I don't have a ride. He lives in South Point. It's like 5 miles away.
Yeah.
That's not, it doesn't matter where you live. You got community service, you gotta get there and do it, or go to jail, because once you go to jail, you can sit on your cot all day. You don't have to worry about any transportation. It's all provided for you. So getting to do community service is a privilege. It's in lieu of, instead of going to jail. And it does, it doesn't cost the county much. You go to jail, we gotta feed you. You don't want to eat jail food. You don't want to sleep there. So just take care of this, do your community service, and do anything else that I order you to do, and you won't have to see the inside of the jail.
Yes, sir.
Oh, she's still here.
I'll set a review hearing for you July 6th of this coming year. So you got half a year to get all this done. We're going to have more stuff to do on your OBI. If you can't afford to pay the fines, I'll let you work it off. You get extra credit for every extra day of community service you do. You get $50 credit toward your fine. Okay. Then on the OBI. I'll give you the minimum fine. I know you don't have a lot of money, so the minimum I'm allowed to give you is $375, so that's bad enough. Your fine's $375. No court costs because I'm putting it on the other case. On this one, I thought I saw it on the, okay. One court cost, she says she's putting it on the OBI. You don't have a license, but I'm going to suspend you from getting a license for 6 months. So you won't be able to get a license for 6 months. Another 20 days in jail, and I'll suspend all this on the conditions you do the other stuff that I'm ordering you to do. Another 5 days of community service. So you got, because I always do that on OBI, but you got the donut stuff you got to pay for too. So you got 10 days of community service total between the 2 cases. 2 years of probation. Your probation will end once you do everything, so it shouldn't go 2 years. You do have to go to what, on your judgment entry, it says DIP, that stands for Driver Intervention Program. Ohio requires it, so because you don't have a license. Whenever you go to get a license, either it's West Virginia or Ohio, they require this 3-day program. So you gotta go do that. Mr. Major will explain to you what you gotta do to get signed up for that and complete it. And that's an inpatient program. So what's that mean? You gotta go in and stay for 3 days and get talked to about the dangers of driving under the influence of different substances. So that's required. Or I gotta make you do, Ohio law, the legislature says, I gotta make you go to jail or go to the program. You'd rather go to the program than go to jail.
Yes, sir.
Same review hearing date, July 6th of 26. You got a no operator's license. I'll give you a $50 fine on that. Get your driver's license. You can't exist. You can't live around, it's not New York City. If you're in New York City, maybe you don't need a driver's license, you take the subway. If you live in Wayne or Chesapeake, which are pretty much the same thing, you need a driver's license. Because you gotta get around. She should not have to haul you around everywhere you need to go. Or your parents. I don't know how you've been getting around for the last 4 years, but get a driver's license. You're not gonna be able to for a while, but eventually you will. Get it done.
Yes, sir.
No excuses. Then, is that it? I guess that's it. Okay, that's all your cases.
Thank you, Judge.
Okay, Mr. Curry, do you have any questions?
No, sir.
You gotta go see the probation officer. His office to the left, as you go out of the courtroom, 90-degree left, west.
Yes, sir.
There, open counter, that's his office. So go talk to him, sign some paperwork, then you're free to go.
Thank you, Judge.
Okay, and listen to her next time she tells you not to do something.
Yes, sir.
Are you related to any of the Currys from Chesapeake? Tom Curry?
I have no idea, sir.
Okay.
State of Ohio versus Anthony Bailey, case number CRB 25790, PRC 253013, A and B.
Okay. Yeah.
Yes, sir.
Okay, so you're Anthony Bailey, 253013, 2579.
Yes, sir. Yes, sir.
Okay, you got the same charges as your friend did, so criminal damaging is 790. It's alleged that on December 7th, in Union Township, you caused damage at Sims Creek boat ramp without the right to do so. That's a second-degree misdemeanor, maximum penalty 90 days in jail, so a $50 fine. And that you were operating a vehicle while being under the influence of alcohol or drugs, and refused to take tests. And you're also charged with failure to control. So apparently you do have a driver's license. Those are your two charges on the traffic: operating a vehicle intoxicated and failure to control your vehicle. Operating a vehicle intoxicated carries a maximum penalty of 6 months in jail, $1,075 fine, 3-year license suspension. The minimum is 3 days in treatment, $375 fine, 6-month license suspension. The failure to control is a minor misdemeanor, maximum penalty $150 fine. So do you understand all these charges?
Yes, sir.
Do you understand the rights you have? I explained at the beginning of the court.
Yes, sir.
Any questions before you enter a plea?
No, sir.
What plea do you wish to enter?
Guilty.
Guilty means you're admitting these charges are true. By doing that, you waive the right to have a trial, make the state prove the charge against you, and to have a lawyer. Do you understand all those things?
Yes, sir.
Okay, so I just read the report, and it looks like it's the very same one for you and your partner there. So I think I understand what happened. Is there anything you want to tell me about the incidents that happened on December 7th, the morning of December 7th?
No, sir.
Okay. And are you working?
Yes, sir.
What do you do?
I'm a concrete finisher in Huntington, West Virginia.
Who do you work for?
Paving Solutions.
Okay. How old are you?
I'm 19 years old.
And I've got on your, at least your OVI charge, it's got a Jefferson Avenue address. Is that where you live? Or?
Yes, sir.
Okay. So you got a West Virginia driver's license?
Yes, sir.
Did have proof of financial responsibility, so that's good. Insurance, you got insurance,
Yes,
right?
sir.
It's gonna go up now. It'll take a few years for it to drop off. If you keep your nose clean, it'll drop off to, well, drop off to regular rates. It's never gonna be, it's all unreasonable. The insurance companies have more money than God. I mean, there's a reason. They collect a lot and pay out little. So that's their business plan, but you gotta have it. Okay, so let's start with the OVI. I'll give you the same, everybody, $375. That's the minimum I'm allowed to give you.
Yes, sir.
$375 fine. Court costs, 6-month license suspension, so you will have a license suspension because you got a license. I'll give you, there's 2 ways we can do this. I'm going to say you probably want limited driving privileges. I can give you unlimited, but then you got to go put the glove, the device on your vehicle, which blow and go, they call it, where you breathe into it before you can start your vehicle, that's probably gonna cost you about $1,200 if you wanna do that. So I can give you limited driver privileges, which you'll have a piece of paper that says, Mr. Bailey's allowed to drive for these reasons, and you gotta prove you're in compliance with those reasons. You won't be unlimited. So I'm guessing you want the limited driver privileges. Is
Yes,
that
sir.
right? Okay. So I'll give you a permit to drive for work, come to community service. Anything else that you think you need a permit for?
No, sir.
Got any kids?
No, sir.
Okay. So if you get stopped, you're gonna have some explaining to do. So the thing I say is, it's pretty easy not to get stopped. Obey the traffic laws. Don't speed. Use your turn signal. Stop at stop signs. Because once you get stopped, you're gonna have some explaining to do, because it's gonna show up you're suspended for an OVI, and that gets them more excited. There's an alcohol-related offense there that you got suspended for. Okay, you got 5 days of community service to do. I told him about that. He needs to be out there helping fix the divots in the boat ramp. You gotta go to the 3-day school, and your review hearing is July 6th. On the failure to control, I'll give you $20 fine. And then on the criminal damaging, I'll give you the same I gave your buddy. 20 days in jail, all suspended, on the condition you do another 5 days community service. So you got 10 days total, 2 years of probation that'll quit when you finish everything. Same review hearing date, July 6th. So both of you will need to go meet with Mr. Major, who's the probation officer.
Was there a fine on that, Your Honor?
Yes,
I wasn't at her for the other one, I'm sorry.
I think it was, no, that was the, yeah, driver's license. I think it was either 100 or 200, $200 fine. Okay, I think that's everything. Go see Mr. Major to the left as you go out the lobby. You're free to go up to that.
Thank you, sir.
You are.
State of Ohio versus Joshua Harris, case number CRB 25741, CRB 21583, CRA 21289, CRB 2129.
Okay, so now I've got the new charge, and there's some old cases here too. And it looks like Mr. Steyer was your lawyer on this one case, 21-583 and 21-289, 290. $21,999. So Mr. Steyer, this is Joshua Harris. You had represented him on some prior cases that look like they're still pending. I'm showing that there was a warrant for failure to appear at a pretrial back in 21. There's been a warrant outstanding since then, and he's got a new charge of menacing by stalking. He's pled not guilty to. So, and you're asking for a court-appointed counsel, and he told me he has been doing landscaping, I believe, but is not employed now, so I'll appoint you on this. I want you to go over the new file with him and the old files, and then we'll come back and decide what the bond should be on this. So you want to take the court's files, because I know you don't have your files.
No,
Let the bailiff know when you're ready to discuss bond.
Thank you.
You're welcome.
State of Ohio versus recalls Jacob Lee Lindsay. Case number CRB 25788 ABC. Where I was given a document that's supposed to show the food service.
Okay, I do have something from Lawrence County Humane Society. It has the date on it. But I don't, when I'm reading it, it doesn't order him to come into court that day. If you read it, it basically says, we're taking your animal, and there's going to be a hearing on Friday, December the 12th, as to whether the court will order the animal continue to be impounded. But it doesn't say that you have to appear on these charges. So my take is, I mean, a person could say, well, I'm not going to contest the fact that they're going to take the animal. But it doesn't say you have to appear because charges are filed against you and you're subject to a warrant if you don't appear.
Your Honor, understanding that that may not be a perfect form of service, we have a more emergent issue, and that is that there are still dogs that are out there that are in deplorable conditions. We actually have pictures. Denise Paulus, the dog warden, is here. She may be standing here. She's in the courtroom.
Okay.
She wants permission from the court to go out and get the rest of these dogs. And we have pictures of the dogs that have already been taken and the dogs that are still out there. They're going to die if they don't get relief immediately.
Well, I don't know that do you need my permission to do that? Because they did that on this anyway. I mean, what I would say is if there's probable cause, then I think you can seize the animals. I mean, how many are we talking about?
1, 2,
There's 6.
6.
6 total. But here's the other thing, perhaps, I'm kind of thinking out loud through this whole process. I mean, this charge has been filed. What I would suggest is that if there's an animal control officer who wants to go seize the animals, we probably need to take a deputy or somebody with them to serve the defendant with a copy of the summons and complaint with regard to the criminal charges. And that would also help, you know, not put the officer in danger, he's not a law enforcement officer, but the Humane Society, in order to get these animals.
So I'm the dog warden, I'm not the humane officer that filed the charges. I was just there with him, assisting him, and I have the shelter, so he has to have my help whenever he does remove any animals. The animal that we removed had to immediately go to the ER because of the dog cab. But what I was asking is if I can go seize those dogs, I do need a court to give me that permission so I can take the law with me, to take the officers with me to do that with a court order.
Here's what I would suggest if the prosecutor wants to request a warrant to be issued for Jacob Lindsay and under the circumstances, I can do that. Are you asking for Jacob Lindsay to be arrested on these charges or summoned?
Well, we
The
want
problem right now is there's no
It should be
service that
available.
I can see of the complaint. I mean, this, what I have shows that the animal was seized and that this person had the right to come to a hearing today about the animal being seized, but it doesn't tell him that you're subject to a criminal charge. If you don't appear, a warrant's going to be issued for you.
understandable, and he still needs to be served or a warrant issued so he can be arrested. I think it's worthy of arrest given the severity of the situation. I've never seen anything like it.
Well, if you want to request that, and what I suggest is put a request to the court for issuance of a warrant, can do that, issue a warrant, and then I think it would be safer for you to go to the home with a law enforcement officer. He can seize the animals, and the officer can serve the warrant.
Can the request for a warrant be made orally?
I'd like to have a record of it, if you want to
As a dog
hand
warden,
draft it.
can I don't know what.
Well, I want some I want a written record that the state asked for this. So we can get it done today. We're going to be here a little while, so at some point we'll get it done and get you a warrant issued. So, but, you know, this is one of the busiest days. Fridays are always the busiest day. There's a lot of stuff going on.
I guess my only concern is that the warrant doesn't fulfill her necessity of having law enforcement go to help her confiscate the other dogs. It just,
Well, if you want to put that in the motion, that you want the law enforcement officer to assist.
okay, I'll prepare a motion, whatever. It's going to be a while, because I'm in the court, but I'll get it done.
Okay, all right, thank you.
You're welcome.
State of Ohio versus Alexis Neese, case number CRA 25491, CRB 25365, CRA 25403, TRD 22766, TRD 211431, PRC 183327, set for free trial.
Mr. Smith's case today, set for pretrial.
May I approach your Honor?
Yes. Sounds like she is compliant with treatment and looking for a job now, correct?
Actually, I'm working.
Okay, you got one?
Yep, and I'll start school next month also.
Oh, congratulations.
Thank you.
Where are you working in?
Tim Hortons,
Okay. Where's that, in Ashland?
Portsmouth.
Portsmouth.
Judge, I was speaking with Mr. Hield about there is a pending theft charge from Walmart. She's prepared to enter a guilty plea on that today. I think we can go ahead and sentence her if you want to hold us either way and then continue this other one out because she's still participating in treatment and doing well. But the state would like to clean up their file a little bit, which we have no objection to.
Well, let's run through some of these. We've got CRA 25403. That was a possession of drugs charge that's filed by itself, and that's been pending
Yes.
since last summer. So we're going to let it remain pending.
That's my prayer, yes, thank you.
Then we've got 25365. That's a theft from Walmart, and it was from it was actually from 2024. Looks like it was filed in 2025. Is that the one you're wanting to plead to, June 11th?
It is, Judge. Yeah, the June 11th, yes.
So there's a guilty plea to that offense?
There is, Judge, and the state has a recommended sentence on that.
That's 25,365.
25,365. And what's the recommended sentence?
Your Honor, there wasn't really anything aggravated about the situation. So whatever the court is accustomed to sentencing on a charge such as this, or if the court wanted to delay the sentencing and maybe use that as an additional encouragement for her to complete her treatment, we wouldn't oppose that either.
Judge, we don't take a preference how you want to handle it, but she will have a guilty plea today.
Well, I'm going to go ahead and sentence her only because I got an email from case management section of the Ohio Supreme Court here recently about our numbers, which I sent them an explanation. We've got a lot of cases that go on hold because we're letting people go to treatment. And they want an explanation about that. I don't guess they like that. They like to see the numbers move. So anyway, I'm going to go ahead and sentence her. So, anything you want to say, Ms. Neese, before I sentence you on this?
No.
Okay, to give you some incentive to continue treatment, I'll give you a $100 fine, but I'll suspend $50 if you complete treatment, or you pay court costs. I'll give you 60 days in jail, and I'll suspend all of it on the condition that you complete treatment. And we'll set it, because she's going to come back and say a month or so on the other matters. So
Yes, sir. I'm here the 23rd or 26th of January. Or the 5th, that's not quite a month.
Yeah, we want more like the 20. Let's make it the 23rd.
Okay.
Her review hearing will be January 23rd on this.
Is there any community service, John?
Yes, 5 days of community service. 2 years of level 4 probation. And then we've got 25,365. He's got this. That's what I said. Got to reach the policy. And we've got 25,491, and I believe that is a possession charge that we're going to let in.
You want that set for the same day?
Yes, we're going to set all our cases at January 20. Well, actually, this is not a possession charge. This is a tampering with evidence charge from August of this year. And this had to do with a urine screen. Tampering with a urine screen here at the court. It was charged as an F3. Do we want to let that end, or how do you want to do that?
Yeah, I think we've had discussions about that
We
previously.
did, it was going to depend, Judge, and see, it's more incentive to do something, because that's a very serious charge if you're not going to treat it.
Okay, it'll end, I'll put the next hearing on it, January 23rd. So everything else that she has is our old cases. Everything is set for January 23rd next year. Okay, continue on with your treatment as you are doing. Continue to grow, learn, get better. Make this permanent, your recovery. Okay?
Thank you.
See you January 23rd.
State of Ohio versus Curtis Allen Hooser, case number CRB 25685.
Mr. Smith's case set for pretrial.
Judge, this is a case where there's three parties involved, and one of them is on the dock today. It's Sean Stratton's case, but I can't represent him because I didn't know that he was involved in this. But it's my understanding, to speak to Mr. Heald, they need to look at a couple more things, and we would get a new trial. We'll waive time. And I can't stand up for Mr. Tackett, but maybe Butch could or Luke could to reset that one.
Is that on the docket today?
It is, Judge. And that's one that Sean asked me to handle, and I said I would, but I didn't know it was a party I was involved with.
State of Ohio versus Lane Tackett. Case number CRB 25684 A and B. Lane Tackett.
Well, that makes it easy. Lane Tackett's been called and didn't show.
I'll let Mr. Stratton.
So I'll issue a warrant for him, as he didn't appear today. Well, there is as I look in the file, Mr. Stratton had asked for a continuance.
Oh,
December 29th.
Okay, well, I just saw the docket, thought he forgot to tell me, so that's even better.
So this, Lane Tackett should be on the docket for December 29th, and entered in the file for that effect. And then ask to Mr. Hoosier, how do you want to handle that?
Judge, if we could come back the 5th or 23rd of January, or 26th of January, whatever's better for the court's calendar.
23rd. January 23rd, 10 o'clock.
State of Ohio versus Sean Short. Case number TRC 2545 A and B. Sean Short.
Your Honor, I spoke to Mr. Hill this morning. She's just been released. She had double pneumonia. She was in ICU at St. Mary's. She's now back home, but she's not able to travel in this weather. And I'm going to file discovery today. I would ask we come back the 5th or 23rd of January.
It's my understanding that Mr. Smith has gotten the verification that she is ill. I am trusting that he is correct on that. We're not opposed to it.
Yeah. She is home now, but she was just released from ICU with double pneumonia. And today the weather, I hate to get her out. And I'm not sure she can even speak that well up here by Zoom today.
At the defendant's request, case is continued to January 23rd.
And Your Honor, I think, and it's a pretrial, I'm not sure, but the doctor may be on Zoom. If we could release him from Zoom. Do you know what his name is?
Thomas Moore.
Oh, Thomas Moore on the screen, Judge, is the physician that is here.
All right, there's a Thomas Moore appearing by teleconference for this Shauna Short. That case is going to be continued, so you don't need to hold on for somebody listening on his behalf. Case is going to be continued to January 23rd. Was this her physician?
I don't think, I think it was a doctor from OVP, maybe?
Yes.
Yes. This is an OVI. She had seen him, as I understand it, left the facility after her appointment, and there was concerns. She was under the influence, and a call was made to the Highway Patrol. So but I'm not sure why he's here for a pretrial, but I just didn't want him to be on here all morning. That the state had requested he be here.
So it's the state's witness?
Yes.
Is someone from the state let his office know he's not going to be doing? Thank you.
Thank you.
Okay, and we don't have all of our evidence on this. I don't think this is the right case. I don't trust anything I'm saying.
Okay, ready to move through? Okay.
State of Ohio recall Jacob Lindsay.
Okay, I have the request or judgment entry from the state on Jacob Lee Lindsay. I'll go ahead and direct the clerk to issue a warrant. So, get that issued from the clerk's office. I signed the entry. Maybe Dorothy prepared it. I don't know. Somebody prepared an entry.
I did it.
Okay.
Thanks, Dorothy. Actually, I wanted to do an entry too, not asking you to do it, but an entry directing them to assist.
If you want to see what she did, and if you want to supplement it, maybe.
Yeah.
She got it started for you anyway.
State of Ohio versus Jared Stover, case number CRB 25-501, CRB 24-461.
There's another one. That's all you need. That's fine.
This is Mr. Smith's case.
It is, Judge. I think we're in the process of trying to resolve this. The complaining party is not here today. I have received some reciprocal discovery I've shared with the prosecutor just this morning. I just got it. I would ask we come back the 5th, 23rd, and 26th of January to allow the state to review the evidence or the discovery I gave them this morning.
Mr. Hill?
That's correct, Your Honor. I got some audio from Mr. Smith, and we do need to look at that and also talk about everything with the alleged victim.
January 23rd?
Be fine, Judge, yes.
January 23rd, next hearing, pre-trial. There was also a review. I'll keep it on for the same time. It looks like it may be finished. There was restitution, it appears to me that was completed. Now, there was a treatment order with OVP at the time, so I don't know if that's completed.
I was arrested after the OVP thing. I went to the Bluffs, yeah, and I spent 35 days there. I'm currently in treatment with the Valley Health.
Okay, well, what I'd like to see at the next hearing is some report. I don't have anything from the Bluffs
Okay.
or Valley Health.
Authorization.
So next hearing is January 23rd.
Okay, thank you, Your Honor.
You're welcome.
Thanks. Yeah, absolutely.
State of Ohio versus Dylan Adair, case number CRB 25-609.
Judge, I don't know him, so I don't know if he's here or not.
Dylan Adair, except for pre-trial.
Yes.
Oh, that's in, is he in Columbus, it looks like?
I think he's in bright lights or white light.
Is there anyone on teleconference for Dylan? Is it Dylan that's on the top corner here?
This is Dylan.
Yeah, Dylan Adair, is that you, sir? Yeah, okay. Where are you, sir, right now? Okay, your microphone's not on. I don't know if you can hear me, but we can't hear you. See your lips moving, but nothing's coming out. Okay, I'm going to hit the ask to unmute button. Here we go. Do you see something on your screen that says, turn on the microphone? All right. How about now? Try it again. No, still not getting anything. actually showing, it's not, now it's not showing that you're muted, but nothing's coming out on this end. Can you shake your head if you can hear me? Okay, I don't think he's hearing me either.
He's shaking his head.
Oh, he is? Okay.
You gonna write down something?
Well, this is one of the bad things with lawyers just taking off, is because this guy's in Columbus at a treatment facility. Okay. It says your microphone's not working. Do you have a phone number where you can be reached? Can you hold up the phone number where we can call and reach you?
He's still talking.
Okay. Your microphone's not working. Is there a phone number you can be called? If you can go try to find out that information or go to another computer, we'll come back to you later.
State of Ohio versus Thomas Mark Baker, case number CRB 25598, CRB 24747. Set for arraignment.
Okay, Thomas Mark Baker.
Yes, Your Honor.
That's you?
Yes, sir.
Okay, and the other gentleman?
Michael Drennan. I work at the Canal Valley Fellowship Home. He's currently there.
In treatment there?
In treatment there.
Okay. All right, well, I've got actually two charges here.
Yes, Your Honor.
Okay, Mr. Dillon, we'll be back with you shortly. Sounds like you got your microphone working. Or maybe that was Corey Road, I don't know. All right, I actually have two charges here, 25,598, 24,747. So the 25,598 is the most recent. It's a domestic violence charge. It alleges that on September the 5th of this year, 2025, that Thomas Mark Baker in Union Township, by threat of force, knowingly caused Shauna Wood to believe would cause imminent physical harm to Shauna Wood or a member of her family, and that Shauna Wood is a member of your family or household. And it's alleged that you've got a prior conviction for domestic violence, so that makes this a second-degree misdemeanor. Maximum penalty, 90 days in jail, $750 fine. Then the 24,747 case number alleges that June the 1st through August of 2024 in Union Township, you purposely tried to deprive Shauna Wood of property without her consent. That's a theft offense. Maximum penalty, 6 months in jail, $1,000 fine. Do you understand the two charges?
Yes, Your Honor.
Are you Shauna?
Yes, sir.
Okay. Were you here when I explained the rights of defendants?
Yes, Your Honor.
Do you have any questions about that?
No, Your Honor.
How do you wish to plead to these two charges?
Not guilty, Your Honor.
Do you wish to have a lawyer appointed to represent you?
Yes, Your Honor.
And you're in treatment, apparently. Are you working?
Yes, Your Honor.
What do you do?
I work at Thoroughbred Express, and I'm employed at the Canal Valley Fellowship Home.
I have to determine your gross annual income. Do you have any idea what that would be?
Roughly 1,800.
A month?
1,800 a month, yes, Your Honor.
Okay. And do you have dependents?
Yes, I pay child support on one child, which is $560 a month.
Okay, you're eligible for court-appointed lawyer. I'll appoint you, Mr. Steyer. State's opposed to bond?
No, that's what I found.
State's not opposed to OR bond, Your Honor.
Okay. So what that means is I'm going to let you sign your own signature guaranteeing your appearance. So I'll make it a $1,500 signature bond.
We need fingerprinting, Your Honor.
He's supposed to be fingerprinted, yes. So you have to go to the jail to do that. It's in Ireton.
Okay.
Not guilty plea is entered.
No.
Ask to vote.
Oh, okay.
Anything further from the state on this?
Well, Your Honor, Ms. Wood is here. She's the alleged victim, and apparently they have children together. They're no longer together as a couple, but, and of course, one of these, the theft offense alleged occurred in 2024. So I don't know whether it's possible for Mr. Thomas Baker to return any of these items if indeed they were taken. Ms. Wood tells me that Mr. Baker is subject to some court orders out of Wood County, West Virginia right now. And that's, I guess, what's putting him in treatment. Sounds like maybe felony charges. So that's a little more serious than what we have here. Ms. Wood has told me she didn't want me to pursue the charges, but we're not prepared to dismiss anything at this point. So, as I understand, ma'am,
Physically, are you coming here?
you're not requesting the prosecutor to go forward with these at this point?
No.
Okay. But you live here in Lawrence County? Why don't we do this? Why don't we set this out a couple of months anyway to see how things are going to go in Wood County, and then we can adjust maybe as we get more information about that.
Thank you.
So probably set something in February. What's your schedule then?
I have a jury trial scheduled for the 23rd, but otherwise I think I'm available on the various court dates.
Okay, how
at
about
this
the
point.
20th then?
I am available the 20th. Does Monday or Friday matter to you?
Does not matter.
Okay.
I can make
Let's set
arrangements.
the next hearing in both these cases. February 20th, 26th, the pretrials in both cases. February 20th. So ma'am, if things change, you can relay that information to the prosecutor, or you're welcome to be here on February 20th for the next hearing. And I'll also order the condition of your bond, you stay in treatment.
Thank you, sir. Thank you, Your Honor.
You're welcome.
So I'll get your file about talking to a couple minutes, just wait for the lobby.
State will not recall Dylan Adair, case number CRB 25609. Dylan Adair.
I think now he's not there.
There's a hand.
Still on there. Okay, we'll wait.
I just got it.
Okay. Folks, we got a lot of cases, so if you don't get called immediately, you need to hang on. We'll get to you. This is the largest court in Lawrence County.
State State of Ohio versus Chancey Berry at the Lawrence County Jail, case number CRB 21836, CRD 17863. And Lisa Hammonds is on deck.
All right, Chancey Berry, that's you, sir?
Yes, sir.
All right, Mr. Berry, looks like you got warrants from two cases, 21836 and 17863, both for failure to appear, and you got picked up on those warrants, and now you're in custody. Do you admit or deny that you failed to come to hearings at this time?
Yes, sir.
You admit? Is that what you're saying?
Yeah.
One was a no operators and one was a theft offense. Where are you living now, sir?
What is it?
Where do you live now, besides the jail? When you're not in jail, where do you live?
95 Drive.
2404, Kitts Hill.
Yes, sir.
With Tina and Lee Berry.
Yes, sir.
That's your parents.
Yes, sir.
Okay, well, you were supposed to do 5 days of community service and pay a fine on the theft offense, and then on the driving under suspension, same thing. You had some community service and a fine to pay. I'm not showing that you've done anything on either case. So what do you say about that?
I forgot.
Okay, well, that's not a very good excuse. You want us laid out in jail? Let's see what you got in jail time. 10 days on the theft offense, and on the driving under suspension, you didn't have any, you just had a fine. You didn't even have any jail time. So how many days you got in jail now?
Since September 17th.
You been in jail since then?
September 18th.
Okay, on something for common pleas?
Yes, sir.
Okay, let's just end the torture on this then. Well, I'm gonna send you to time served that you've been in jail all this time on these other cases, and you don't have to worry about coming back to this court. Case completed by jail time. So your cases are over here.
Thank you.
You're welcome.
State of Ohio versus Lisa Hammonds, case number PRC 141590, A and B, CRB 14465, and Justin Horns on that.
Lisa Hammonds. Okay, I didn't think you were going to be in jail.
Judge,
Yeah.
she appeared in front of common pleas this past Wednesday on a motion to revoke probation. She was sentenced to STAR beginning December 15th and had her probation extended to 5 years.
Okay. So you had an ODI in this court where at one point you were ordered to go to treatment. And that was recently. Did you ever go to Bethesda?
No, I've been here waiting to see what Finley was going to do, and she sentenced me to go to STAR Tuesday.
Okay, well, here's what I'm going to do then. I'll complete your case by jail, and, I mean, you're going to get treatment at STAR. The difference between Bethesda and STAR is when you go to STAR, there's a fence with barbed wire around the whole facility at the top, and you can't leave. Even if you want to leave, it's like, I don't want to do this anymore. You got to climb over the fence and the barbed wire to get out. At Bethesda, I'll send you there. It's a faith-based. You can walk out the door anytime you want to. There's no barbed wire or fence around the facility. So you're going to get treated at STAR. So Hopefully that goes well for you, you get in recovery. I'll just let common police follow you from now on. Your case with me is completed by the jail time and treatment you're getting in SART.
Okay,
Good luck to you.
thank you.
You're welcome.
State of Ohio versus Justin Horn, case number CRA 25203, and Raymond Jenkins is on deck.
So this is a new case. Are you Justin Horn?
Yes, sir.
Mr. Horn, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. You're appearing here in court today on teleconference. So your image and what you say is all being recorded. You don't have to say anything. You have a right to remain silent. But if you do say things, it's going down on the record. It can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state of Ohio prove the charges against you beyond a reasonable doubt. Do you understand those things?
Yes, sir.
The charge against you is felonious assault. State's alleging Holder, March 20th of 2025, in Fayette Township, you knowingly caused or tried to cause physical harm to Tyler Phillip Chapman by means of a deadly weapon. The maximum penalty for that charge is 8 years in jail and a $15,000 fine. Do you understand the charge?
Yeah.
You haven't made a hire a lawyer?
I don't.
Do you have a job?
I do.
What have you been doing?
I'm sorry.
What job have you been doing?
I work for Apple.
Get paid by the hour?
Yeah, I get paid an hour.
How much per hour?
$18 an hour.
What's the state's position on bond for Mr. Horn?
The state would request, the state would request a $15,000 cash assurance.
And do you think you can post a $15,000 bond?
$15,000.
Yeah, you got, here's the way that works, 15,000 cash or surety, so the surety is a bail bondsman. If you got 15,000 in cash, you pay that to the clerk, as long as you show up for all your hearings, at the conclusion of the case, you get a refund of all $15,000. If you can't pay $15,000, you can hire a bail bondsman, and usually it's 10%. You don't get that money back. It's $1,500, and then if you don't show up for your hearing, the bail bondsman eventually has to pay $15,000 to the county. And they don't usually like to do that. So they go out and hunt you down and snatch you up and take you to the jail for not coming to court. So,
I could probably get a bill on, yeah.
so you want to talk to a bail bondsman then? Is that correct?
Yeah.
Okay, we'll have a bail bondsman contact you. Have you lost your job, or do you think you still have your job?
Over that, I still have
How many hours a week do you work?
40.
Do you have any children?
I have 3, I have 1 on the way to be here.
Okay, then you're eligible for court-appointed counsel if that's the case. All right, Mr. Morford, I'll appoint you to represent Mr. Horn. Setting bond at $15,000, cash or surety, with protection order.
Yes, sir.
So that means you're not, is there any problem for you to stay away from Tyler Chapman?
Yes, sir.
Is there any problem for you to stay with? Is he in the same household, or lives right next door to you, or what's the situation? You can stay away from him?
Yes.
Okay, and when I say stay away, nowadays, I didn't have to say this when I first went on the bench, because it didn't exist. No social media. You don't go on social media and run your mouth or your fingers about this guy or what's happening or anything like that. You do not post things about it. You let everything die down.
Won't be a problem.
Okay. Are you pretty confident you can post the bond?
Yeah.
Okay. So, Mr. Morford, with that being the case, he's not going to be in jail. When do you want to come back for the next hearing?
I can't do it Monday, Judge. I've got a jury trial then. Other than that, Friday maybe.
The 19th?
Yes, Your Honor, I'm here then.
Okay, Mr. Horn, I'm going to set your next hearing for December the 19th, so that's a week from today. At the court in Chesapeake. You know where the court is located?
Yeah.
Okay, you got to be here December the 19th, 10 o'clock. Mr. Morford would like to have your phone number, if you don't mind giving it to everybody in the courtroom and everybody on the World Wide Web, because it's being broadcast on YouTube. You want to give him a phone number, or you not want to give him a phone number?
Probably need the office.
304-563-7888.
Thank you, sir.
Okay, be here next week, and I'd say before, well, around 10 o'clock, that's when your hearing's going to be set. And we'll have, I don't know if Josh even heard. Do you want to get in touch with Mr. Sauer?
I will text him as soon as we finish, Judge.
Oh, okay, the bail's already,
Thank you, Mr. James.
okay. The bail bondsman should be getting in touch with you pretty soon. He's pretty good about that.
State of Ohio versus Raymond Jenkins, case number CRA 25786, and Bryce McGinnis is on deck.
Is Dylan Adair there now? Dylan Adair. I see Dylan. Is that Dylan Adair?
Is he back?
Well, there's a...
I can hear you. Yes, I can hear you.
Okay, we got two going at once here. I'm looking for Dylan Adair. Is he on here? And it would be at a different location, the jail. So if the jail, just sit tight, we'll come back. Well, it's breaking up. No, it's breaking up. I'm getting bits and pieces, but not the whole thing. Okay. Yeah, we're not getting enough to make sense.
Yeah, I'm here.
Nope.
Okay, so we'll come back to Delaware there. Whatever you're using there is not coming through. You need a different location. All right, so at the jail, we have Raymond Jenkins. Can you hear me, Mr. Jenkins?
Yes, sir.
Okay, I'm Judge Capper. I'm at the Lawrence County Municipal Court in Chesapeake. It's where your case is filed right now. This is your arraignment hearing. You have a right to remain silent. You don't have to say anything. But if you do make statements, what you're saying is on the record. It's all being recorded. It can be used against you. You understand that?
Yes, sir.
You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state of Ohio prove the charge against you beyond a reasonable doubt. You understand your rights?
Yes, sir.
The charge against you is domestic violence with a prior conviction, it's alleged. So the state filed this as a felony, domestic violence, a felony of the 4th degree. So if you get convicted, the maximum you face is 18 months in jail and a $5,000 fine. And it's alleging that, the state's alleging in their complaint that on December the 10th this year, you knowingly caused or tried to cause physical harm to Amanda Saunders. And that Amanda either lives in your household or is a member of your family. And that you've got a prior conviction for domestic violence. You understand the charge?
Yes, sir.
Do you have the money to hire a lawyer?
No, I need an attorney appointed to me.
Do you have a job?
I have a job.
What do you do?
I'm security at Stonewall nightclub.
Is that a full-time job?
Correct.
That's every Friday and Saturday, from 9:30 at night till 3 o'clock in the morning.
Okay, are you paid by the hour for that work?
Yes,
How much per hour?
roughly around 15 an hour.
Okay, you're eligible for court-appointed counsel then. I'll appoint, I think we're back to Mr. Smith. I'll appoint Roger Smith to represent you. He's here in the courtroom. This is Raymond Jenkins,
Yes, Judge.
and he has a felony domestic violence charge with a prior conviction. State's position on bond for Mr. Jenkins. And I've got an address, make sure we get the right address. 138 in Ironton?
Yes, sir.
That's it? Okay.
The state wouldn't be opposed to an OR bond as long as we can be sure that he doesn't have to be around the alleged victim, Amanda Saunders.
Do you live with Amanda Saunders?
I do, but I can actually stay with a friend of mine.
Yeah, who's the friend?
Dakota Stilker, he lives in a Roman trailer park at lot 35 behind the Lawrence County Fairgrounds.
Okay, state satisfied with that?
Yes, Your Honor.
So I'm going to release you on your own signature, your own recognizance.
Yes, sir.
I'll make it a $2,000 bond, so you don't have to post $2,000. But if you don't come to court, then you owe the $2,000 and you get a warrant. So come to court, you won't have to post the money, we'll pay it. But further condition of that bond is you have to stay away from Amanda Saunders, not go around her, contact her, or post anything about her on social media. You understand that? And then we'll come back to court. What's your preference on that, Mr. Smith?
Judge, if it's this month, I have the 15th or 19th, then I get it in January. Okay.
Okay, 15th through the 9th?
I'm here this Monday or next Friday, and then I'm here January 5th, 23rd, or 26th.
Let's see what it looks like.
We'll wait time, Judge, since he's getting out on signature bond.
Both of those are, you looked up, would you say the next one was the 23rd?
Yes, the 23rd or 26th of January.
Well, I think we better do the 19th then,
Of December?
of December.
Okay.
That's a long ways off. Okay, Mr. Jenkins.
Yes, sir.
I'm going to set your next hearing for December the 19th. That's just a week away.
Yes.
Doesn't seem possible.
Yeah, it's
right.
That's why I got the gap because of Christmas and.
So next Friday, the 19th, you gotta be in court for a hearing. Be a preliminary hearing on your case at the court in Chesapeake. You know where that is?
That's right here near the flea market, am I correct?
That's our claim to fame. We're across the street from the flea market. That's where people know. They know the flea market, they don't know us. So yes. County Road 1.
Yes, sir.
If you're real old, it's old US 52.
Yeah. Do you have a cell phone number I can call you when you get out of jail?
I'll actually have to,
Or you can call me.
my brother's cell phone.
Okay, give me your brother's cell phone. He can get a hold of you, right?
Yes.
Okay, give me your brother's cell phone.
All right, his name is actually Jeremy Halen,
Okay,
and it's 304
okay.
544
544, yes, sir.
6128.
Okay? All right, I'll call you, probably Monday, but I'll call, we'll make arrangements, get you in the office, okay?
Okay.
State of Ohio versus Bryce McGinnis, case number TRD 252808, and Taylor Parmenter is on deck.
Hey, Roger.
All right, Bryce McGinnis is Mr. Stiers' case. He's here for pre-trial.
Just once,
He had missed a pre-trial previously, and the bond got forfeited, and.
Yes.
This is the US and the
Your Honor, this is driving under OVI suspension. Mr. McGinnis was working on getting me some proof that he was driving within driving privileges. He did have limited privileges at the time, so we were looking for some proof of the driving at the time of the alleged incident was within privileges. How long has he been in jail?
Well, the entry went on December the 5th, so sometime before then.
Have you been in for at least 3 days, sir?
Yes, sir. He failed to appear for a pretrial on November 24th, then he got arraigned. He got arraigned on December the 5th, so I'm not sure when he actually went in.
He was booked into jail on the 4th.
He was booked into jail on the 4th,
So he's been in for a week, Your Honor. This matter is one that has a mandatory minimum of 3 days. The state just made an offer to me that if in exchange for a guilty plea, they would ask for time served. That would cover the mandatory minimum. Now, I would explain to Mr. McGinnis that the court might put a fine and/or community service on him in addition to that, but that if the court was agreeable with that, he could potentially get out of jail today, assuming there's nothing else holding him.
There's also a failure to control. Looks like there must have been some kind of wreck on this. This was out of what's from the sheriff's office.
Yes.
Oh, and this was, he collided with fencing at the Collins Career Center.
Oh, okay, I see some pictures.
An estimate to fix and replace the damage. Yeah, $2,000 to replace the fence.
Did you have liability insurance at the time?
Yes, sir. Who was the company, do you know?
It's the Collins Career Center is where.
No, I think the question is, what was the insurance company?
Oh.
Darren.
Here's a copy of the.
You want the Collins Career Center to have a chance to come in and present their damages, or how do you want to, do you have something from them?
Yeah, there's an estimate from the White fencing company.
The estimate's for $2,000.
Do you wish to agree to that?
Well, I'm gonna put that to Mr. McGinnis if he, that would be part of what the situation would be that there'd be, order of restitution for $2,000, which to some degree you might be able to satisfy that through your insurance company.
It should say, if he had liability, it should take care of it.
That's what I would think. I don't know if you've presented this to your insurance company, but if you haven't, you could present it to your insurance company and they should take care of that. So you have that option, or we can ask for another date back.
I'm sorry, what's that?
You have the option the state has indicated that they would be satisfied by time served if you were to plead guilty on this, and then they would be asking for $2,000 restitution. You can accept that, or we can ask for a date back and we can try to get you out of jail, but you don't have a bond right now because your bond's been revoked.
Well, he has a bond, he just couldn't post it.
Oh, it hasn't been, okay.
Yeah, I revoked it, and I said a new one. I said, so you gotta pay the $1,500.
Right.
He had a bond they didn't show up for, and then I said a new bond was $1,000 cash for surety, so.
Right.
He,
Or we can set another trial, another date, or set a date for a trial at this point, and you either have to post the bond or sit in jail until that trial date.
But with the first option, let it out.
Well, this judge has to say yes, which he hasn't said he would say yes yet, but I anticipate he probably would because you've been in there 4 days more than the mandatory minimum, but he's going to have to answer that question. And he doesn't actually have to answer that before you make the decision. He's not bound by our recommendation.
Well, that's the first one.
Okay. In that case, Your Honor, we'd like to enter a guilty plea at this time, and I would join in the state's recommendation that he be given credit for 7 days in jail, credit for 7 days time served. We would stipulate the amount of the restitution, although ask that if he's able to get his insurance to cover that, if he could present that to the court, have the restitution, I don't know if it'd be waived or considered satisfied.
Sure, yeah, the victim is only entitled to one reimbursement, they're not entitled to two, so they can't claim from him and from the insurance company. So whoever pays him, he gets credit for, or pays them, he gets credit for. All right, so Mr. McGinnis, your attorney is representing the court that you wish to change your plea to guilty, is that correct?
Yes, Your Honor.
And you have a right to make a statement to the court. Before I sentence you, do you have anything you want to say?
No, Your Honor.
Okay, I'm going to accept your guilty plea. The minimum, I'll give you the minimum fine, which is bad enough. This statute, the minimum is $250, so that's the least I can give you as a fine. So your fine will be $250, or you pay the court costs. I'll sentence him to 20 days in jail, and I'll suspend 13 and give him credit for 7 days. He's already 8. 7, we'll say 7. It finishes it out. So you're reading it out today. I will order that you make restitution to Collins Career Center for the amount, was it?
It's $2,000.
$2,000 for the fence that you tore down with your car. So what you should do is just turn it into your insurance company. That's why you carry liability insurance. It was your fault that you caused this. So they have to pay any damages you cause. So turn it into them. But ultimately, in this scenario, between you and Collins Career, you're the one that's responsible. And if they don't pay, I'm going to make you pay. So it's in your best interest to get with Dairyland and make sure they pay the claim. I'll set a review hearing for you July the 6th. So that's a long ways off, and you're like, you need to let this register in your brain. July the 6th. That is the first Monday in July of next year. You have to be in court. So here's a way you can mess this up and go back to jail. I don't want you to go back to jail. You've done your jail time. But if you blow this off and don't pay your fines, don't make sure that Collins gets paid their restitution, and then don't come to the hearing on July 6th, guess what? You're going to get a warrant, and you'll wind up going back to jail. I don't want that to happen, but that happens a lot. You need to be a little scared of going to jail. A lot of people aren't scared of going to jail, and they blow stuff off and don't do it, And they wind up getting a warrant, and it's like, oh, I'm surprised I'm going to jail. Well, you didn't do what you were supposed to do. You gotta do what you're supposed to do, and then you can stay out of jail. Does that make sense?
Yes, Your Honor.
It makes sense to me. I don't get it why people, you've been there. And there's a lot of people, probably 50 people here watching you. Would you tell them to do what you need to do to stay out of jail?
Yes, Your Honor, I will.
I tell them that, and they don't pay attention to me. You're a man that's been living it for the last 8 days. Maybe they'll listen to you. Do what you need to do to stay out of jail, folks. Okay. Your review hearing is July the 6th. This is the only notice you're going to get. But if you forget, that's another excuse. I forgot, Judge, what I was supposed to do and when I was supposed to be there. Is that a good excuse? You tell me right now, is that a good excuse? No. We actually have phones here that work. You can call the court. Please be quiet over here, these people. You can call the court. Okay, on the failure to control, I'll give you a $20 fine. You had that too. You can call the court, you can check the website with your smartphone, which I know you have.
Yes, sir.
The website for the court, and see when you're supposed to be back in court. No excuses. Okay, July 6th, we're going to get out as soon as we get the paperwork done here at court, so it won't be too long. You don't have to go home, you won't be able to stay at the jail.
State of Ohio versus Taylor Perimeter, case number CRA 23-189 A and B, CRB 23-191, and Donovan Riley is on deck.
Taylor Perimeter. Okay, she's in the jail. All right, Ms. Perimeter, it looks like you missed the hearing back in February for review, and it was on a endangering children charge.
Yeah, I was at Linda Reeves then.
Did you finish there?
I went to Linda Reeves, I graduated and everything, and then I went to the psych ward and back to Linda Reeves, and then I've been in jail since.
When did you go to jail?
August 4th.
You got something in common pleas then?
Yeah.
Okay. You did all your community service and you paid some on your fine, you just had a small balance left. So since you've got something pending in common pleas, I'm just gonna finish you up here, whatever, you've been in jail a long time. So that completes your case. Your case is completed by jail. So you can worry about common pleas, not this court.
Thank you.
You're welcome. Good luck to you.
State of Ohio versus Donovan Riley, case number CRB 25-785, CRA 25-787, and Laura Thompson is on deck.
Sir, are you Donovan Riley? Are you Donovan Riley?
Yes, sir.
Can you hear me okay, Mr. Riley?
Yes, sir.
I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. Your charges are filed here today. You're appearing in court by teleconference, obviously, you're not here in person, but your image is being recorded and everybody that's sitting in the courtroom can see you, and what you say is recorded. So you don't have to say anything. You have a right to remain silent.
Okay, sir.
If you say stuff, it's on the record, it can be used against you. You have a right to have an attorney, to have one appointed, if you can't afford an attorney. You have a right to bail. You have a right to make the state prove this charge beyond a reasonable doubt. Do you understand those things?
Yes, sir.
The charge against you is theft. It's alleged to have happened at the Walmart in South Point, that's Fayette Township, on December the 11th of this year. It's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. you understand that charge?
Yes, sir.
How do you wish to plead to the charge?
What is it, sir?
How do you plead to the charge?
Guilty or not guilty? I might have done it, I'm not gonna lie.
Well, if you're not sure, not guilty is the safest plea. If you enter a guilty plea, it's a complete admission that the charge is true, and you waive your rights to have a trial and have a lawyer. If you don't want to do that, or if you're not sure what to do, not guilty is probably your best bet, because it preserves all of your rights.
Well, not guilty then.
Do you have, well, here's the other thing. This is not the trial today, so it's not going to go away because you're going to magically tell me something and start, oh, you're right, I'm going to dismiss this. So the trial will happen down the road, not today. So smart thing to do if you're entering a not guilty plea is wait and talk to your lawyer, because everything you tell your lawyer is privileged, cannot be used against you. Everything you say between me and you is not privileged. It can be used against you.
Yes, sir.
So let's decide if you're entitled to a court-appointed lawyer. Do you have a job?
Not at the moment, I'm still living.
Oh, okay. You're in treatment right now, or have been?
Yeah, I have been restoring hope in South Point.
When's the last time you worked?
It's been like a month ago at Superior Marina.
You work for Superior Marine?
Yeah.
Okay. I know those folks pretty well.
I just came back from Columbus from getting off methadone, and I've only been back maybe 2 weeks back up, restoring hope though.
Okay.
So I haven't been back to work.
Well, you're probably not feeling too good then, are you?
I'm fine right now. They told me I had a warrant out of Logan County, West Virginia, I guess, for I was on probation in court order to, restoring hope, so.
Okay, well, that might be a problem then, because I'm probably not going to be able to get rid of your case today. If somebody needs to check to see if he has an outstanding warrant, because that's going to stop me from doing anything until we clear up that warrant from, if it's a felony. Do you think it was a felony?
Hey, Your Honor, this is also Mr. Riley, he does have a warrant out of Logan County. We faxed it down this morning.
Okay.
I'm not sure if it's felony or not, but I do believe it has due probation.
I have an extradition
Yeah. Jacob Lynn? No.
on the CRA 25-787, you haven't counted on.
No, but I do have here, I just overlooked it. So, okay, you do have a warrant out of Logan, West Virginia, so I've got that. Circuit Court of Logan County, West Virginia, case number 23F 214. And they are asking says, to any law enforcement officer. CAPE has been issued by the judge of this court against the defendant. It names Donovan Tyrone Riley. Finds the defendant has been convicted of a felony offense and has allegedly committed a violation which would require the defendant to be sentenced to the custody of the West Virginia Division of Corrections and Rehabilitation. Probation violation, it says. So they are asking for you. So in light of that, what's the state's position? You still want to plead guilty to this?
No, not guilty.
To the theft offense? Okay.
Yeah.
Well, Mr. Steyer, you have umpteen cases today. Do you want this one too, or have you got enough for today?
I can go ahead and take one more.
Okay, I'm giving you a West Virginia lawyer. You got West Virginia problems. And you got a problem here too. He's got a holder out of Logan County on a felony probation violation, and he's got a theft offense here. Did Logan County send you to treatment here in Lawrence County?
Yeah.
They did?
Well, I was in Huntington at first, then I switched to Lawrence County.
Interesting. Okay. I don't think he can get out even if I set a bond, because Logan County warrant's gonna put him in jail, but in case they lift that, I guess I should say bond. I'll make a 2,500 cash or surety bond on the case I have.
Thank you, sir.
But you probably, even if you post that, you probably can't get out because the Logan County warrant's gonna trump it until it gets lifted.
Your Honor,
When are you gonna come back?
I'm here next Friday, and I'm here the following Monday. I think next Monday's probably a little too soon to get anything done, but if we could come back either the 19th or the 22nd.
Let's do the 19th. Okay, your next hearing, Mr. Wiley, in case something happens, you get out on bond, you gotta be at the court in Chesapeake next Friday, December the 19th. That's probably not gonna happen. You're probably still gonna be in jail, I predict. But if you do, you gotta get yourself to court on the 19th by 10 a.m. that morning.
Okay.
And, you need anything else?
I don't believe there's anything else for the moment.
That's all.
Has he been arraigned on the extradition as well?
Yes.
Perfect.
No, I'll have.
Yeah, I just arranged you on it.
Perfect. Thank you.
State of Ohio versus Laura Thompson at the Lawrence County Jail, case number CRB 25384.
All right, this is Mr. Steyer's case. It's set for a pretrial there.
Well, have him called up.
This is one where she had failed to appear for a pretrial back in August, ordered the OR bond forfeited and said a new bond she hasn't been able to post.
This is a M4 drug paraphernalia case from back in May. I'm not certain how many days total she has in, but she's been, my understanding is she's been in at least since the 1st. Thanksgiving, okay.
She was arraigned on the 1st, but she probably went in before then.
So she's got at least two weeks in at this point, and Mr. Heald had offered that in exchange for a guilty plea, he would be satisfied with time served.
She went in November 26th.
Okay, so that's 4 days in November, and today's the 12th, so 16 days minimum. I don't know if she had time in prior to that or not, but I think that those 16 days are probably sufficient for a drug paraphernalia charge. And so I'm going to put to her that the state is offering that in exchange for a guilty plea, they would recommend, and we could join in the recommendation, that you be sentenced to 16 days in jail with credit for 16 days served. Now, we didn't hear me say this because you weren't on the video, the judge isn't bound by that, but it's not so unreasonable that I think he's unlikely to agree to it. And if there's nothing else holding you, there's a decent chance you get out today. Now, I don't know that there's not anything else holding you, but I don't think there's anything else in this court holding you.
No. There's nothing else holding me.
Then with that in mind, Your Honor, we're going to enter a guilty plea and join in the state's recommendation of 16 days in jail with credit for 16 served.
Do you agree with that, Ms. Thompson?
Yes.
You have a right to make a statement to me if you want about this case. You don't have to, but you have a right to do that before you're sentenced. Do you have anything you want to tell me? Okay, I'll accept your guilty plea. I'll impose a $50 fine and court costs. I'll sentence you to 20 days in jail, suspend 4, give you credit for 16 served. Set your review hearing for July the 6th. So you've got fine and court costs to pay. And you need to do that or show up, and you do have to show up for your review hearing if you haven't paid it. You can actually work it off. If you can't pay, do some community service, you get $50 a day credit. Community service. And you can do community service here at the court every day, it's Sunday or holiday, at 7:30 a.m. You will get out here shortly once the clerks get the paperwork finished and sent down to the jail. Okay, good luck to you.
Thank you, Your Honor.
Thank you.
Okay. Finally, we're finished at jail. Let's try Mr. Adair again. Dylan Adair.
I'm here.
Oh, we can hear you now. Okay, great. Finally found that you had to get the right switch turned on or a different computer or what? Can you hear me? Okay.
Yes, I can. It's a little, I can hear you, but it's unclear.
Okay. Now, what facility are you with right now?
I'm at the same facility, but I graduated the program I was in, and I went to an intensive outpatient.
Okay. What's the name of that program?
It's the same place. It's White Light.
White Light?
They have a partial housing patient. That's the one I was in. I graduated that. I'm now in intensive outpatient.
Good. That sounds good. What's the state's position for him?
Well, that's good to hear. Sounds like he's maybe benefited from the experience, and he'll continue to. We would like to continue to follow him and make sure that he finishes all the programming that they provide.
Okay. Your lawyer is not here today. Mr. Smith is standing up for him. So you've got some dates when he's
I do, Judge. I just spoke with Mr. Stewart, texted Mr. Stratton. The only bad dates are January 12th and January 20th. Aside from that, he says whenever it's convenient for the court.
Okay. So I'm going to set Mr. Adair a different date. About a month out, we'll come back for another date. And you can appear by teleconference then.
What day is it?
Well, I haven't set it yet. I've got to get my computer up. It tells me how many cases are set each day, and I got to look at that before I set.
How long? Do I need to call my lawyer to get the date?
No, I'm going to give it to you right now. I'm looking at the computer.
Okay.
So let's do it. Let's make it easy to remember. Exactly 1 month from today is January 12th. Now that's a Monday, not a Friday.
That's the bad, the 12th and 20th, yeah, I'm sorry, the 12th and 20th are bad days.
Okay, forget what I just said. So let's go to the 16th. That's the Friday of that week.
Okay.
January the 16th. And you can appear just like you are today by teleconference. And hopefully things continue to go well for you there at White Light over the next month, and we'll get a good report then.
Thank you.
Okay.
Thank you, Judge.
See you on the 16th.
I'll let Mr. Stratton know.
All right, bye.
Bye.
State of Ohio versus Catherine Metzger, case number TRC 253020, A and B.
Okay, this is an arraignment today.
You Captain Metzger?
You should also have CRA 2571.
I do have. Yeah, it's in the file. Ma'am, are you Catherine Metzger?
Yes, sir.
Ms. Metzger, I've got, it's like 3 charges to go over with you. The most serious one is CRA 25791. It's a improper handling of a firearm in a motor vehicle. It's charged as a felony 5. And it alleges that in Fayette Township on December the 8th, you knowingly were transporting a loaded handgun in a motor vehicle while being under the influence of alcohol or drugs of abuse, or a combination of those things. So that makes a felony 5 carries a maximum penalty of a year in jail and a $2,500 fine. Then you've got some misdemeanor charges, 25, 30, 20, and A and B. The A case alleges that on December the 8th, 2025, at 9:11 p.m. in Fayette Township, you were operating a vehicle while being under the influence of alcohol, drugs, or a combination of those things, and that you refused to take tests. And it's a first offense. On a first offense, the maximum penalty, 6 months in jail, $1,075 fine, 3-year license suspension. The minimum you can get if you're found guilty on a first offense is 3 days in a treatment program, $375 fine, and a 6-month license suspension. Then the last charge is failure to control your vehicle. That's a minor misdemeanor, has no jail time with it. Maximum penalty is $150 fine. Okay. You understand those three charges?
I do.
I don't think I went over specifically, and I've done it several times, and I think you've been here for it, but all defendants have certain rights that I have explained a few times. Were you here when I explained the rights of defendants? Do you want me to go over it with you again?
No, Your Honor.
You understand your rights?
Yes, I do.
Do you have the money to hire a lawyer?
I do not at the time, sir.
Are you working?
Yes, I work part-time at a bar and grill serving.
Okay, I have to determine your gross annual income, so I've got judges up above me. They're actually in Columbus, so I should point that way. Tell me what I gotta do. And one of them is determine your gross annual income before I give you a lawyer. So what do you think your gross annual income is?
Probably around 25 to 30,000.
Do you have dependents?
No.
Okay. And you're working part-time? That's pretty good for working part-time.
Yeah.
Okay. Well, if you're closer to 25,000, I can give you a lawyer. If you're 30,000 and you're single, you probably need to hire your own lawyer. So what do you say?
I would say around 25. It fluctuates.
Okay, Mr. Morford, I'll appoint you. Marrying, well, she doesn't need a plea in it because she's got a felony with it, so. She will, you haven't been fingerprinted, have you?
No, not for this, Your Honor.
You'll need to go get fingerprinted, and Mr. Cooper's gonna get you the form to do that with. Any objection to an OR bond since she appeared on her own? Mr. Hill?
I'm sorry, Your Honor.
Any objection to an OR bond since she appeared on her own?
No, Your Honor.
Okay, I'm gonna give you a $2,500 signature bond. That means you're guaranteeing your own appearance. You understand that? You understand what that means?
Yes, sir.
Just show up, you don't have to worry about the money. When do you want to come back, Mr. Morford?
A week, Judge?
Okay, it's gonna be a busy court day, but we can do it. That's the 19th. December 19th. Preliminary hearing and pre-trial, 10 o'clock. Anything else, Mr. Morford?
Not here, Judge, thank you.
Okay, 1 week from today, that's your next hearing, 10 o'clock.
Thank you, Judge.
You're welcome.
State will recall Joshua Harris, case number CRB 25741, CRB 21583, CRA 21289, CRB 21291.
Mr. Stiers' case, so let him speak with Mr. Harris and then come back and set bond.
A complication has arisen. One of the pending charges that's from back years ago has Kayla Harris as the alleged victim. Kayla Harris is not only my client, she's got a currently pending case. So I don't believe I can represent him on that. And with that in mind, I think it might be better to appoint a different attorney for the entirety.
Okay. Well, Mr. Smith, I think we're back to you.
Sounds good.
Okay, anybody in the audience that wants to go to law school, we need lawyers. Believe it or not, there's too many lawyers. No, there's not. We are short of lawyers now. We need some new, not to say that everybody in this room is old, but we don't have any young lawyers anymore.
Fair statement.
We need some young lawyers. So, okay, so here's what we need, Mr. Smith.
Yes, sir.
We haven't set bond. He's got several old cases and he's got a new case. So I need you to look it over, then come back and we're going to decide, get a recommendation on bond.
Sure.
Your Honor, all those old cases, has he ever been arraigned on them, or?
He's been arraigned and he missed a pretrial back in 2021. That's the issue.
Okay, so,
He's had a warrant outstanding for years.
I'll see you later. What were we gonna say?
State of Ohio versus Felicia Hannon, case number CRB 25437. State of Ohio versus Thomas Hannon, case number CRB 25438. Your Honor, I believe proceeded and costs have been paid.
Oh, I'm sorry, I didn't hear the case being called. Your Honor, this was a 90-day continuance. We actually were out a little bit further than that because there was an issue with Mr. Hannon's work schedule, so we moved it to today. It's to be dismissed from payment of court costs, however. I'm sorry?
He has paid the cost.
Oh, costs have been paid.
See that page.
Oh, I've got a note in the file today, 150.
I paid it.
Okay.
Okay.
437.
Yeah, it's on 25,437. The note on, well, that's
Because
hers.
that says
It's actually on his, it's.
Well, I think originally, because he was not represented, we were gonna have her pay the cost,
It is
but,
on her file.
but he's employed and she's not, so I think the money ended up coming from him.
Okay, but it's credited to her case, so.
Right.
In any event, the state was willing to dismiss if there was no further problems, and one court cost was paid, and one court cost has been paid.
Okay. There's been a wrinkle in this, however, which is Ms. Hannon has expressed a desire to have the two of them undertake anger management. And so that wasn't part of the original deal. She's asking for that now. I would leave it to the court and to the state. And then we could come back a little further down the road for a dismissal, because costs have now been paid.
And are you willing to go too, ma'am?
Yeah.
Okay. What's the state's position?
The state's fine with it. Hopefully both of them are fine with it. It sounds to me like they want to stay together, and if that's the case.
I don't think that's the case, but I think they do have a child together that.
We don't.
You don't? Oh, I misunderstood that whole situation. However, that's the desire that's been expressed to me.
Okay. What's your position, Mr. Hannon?
It's fine with me.
Okay. Now, we've got several places that do that kind of work. How are we going to pay for it?
Well, I was going to say, do you have insurance through your employment?
Not currently, but I will.
Well, I mean, that's actually kind of a complicating factor because almost nobody takes insurance that does this kind of work. Do you have a medical card? She has a medical card. Do you have a medical card at this point?
No, I travel jobs, so my job changes.
Right.
My insurance changes.
So is there anybody that is offering anger management, like to speak to them? Okay. So just talk to this guy back here.
He's on RRS, and you folks live here in Orange County, what that is?
I would guess.
Right here in Chesapeake.
Yeah. I would guess that about maybe 60 days or so should give them time to get that taken care of. But do you know if you have any times that you're for sure going to be out of town coming up that we need to schedule around?
My schedule's kind of all over the place.
Okay.
Fridays
Fridays are
are better.
best.
Okay.
Maybe go out about 60 days. And what happened this last time was when he found out he had to work, she contacted me, we changed the date. I'm going to state that we may need to do that again.
Well, as long as everybody's in agreement.
Yeah.
How about the 20th of February?
Let me make sure. I've got one date in February that doesn't work. And that's not it. I'm actually on the docket that day.
Okay, next hearing is February 20th, next year, 10 o'clock.
So talk to them, see if you get that taken care of, and we'll cost her pay as long as you finish that. Okay? Okay, thank you.
State of Ohio versus Al-Hassan Ansari, case number CRB 25626. Al-Hassan Ansari.
Okay, there we go.
Mr. Stiers, please.
He's the only one right now. We're able to reach out to the courts and
stuff, so we can get that moved through. We haven't got it done yet, but we're in the process.
Okay. Your Honor, we have two different matters here today. There's a criminal matter pending before this court, and there is a, I guess a Rule 4 hearing from, Rule 4 matter from Pickaway County. They withdrew their holder to allow him to go to treatment, and they have not required him to appear in person yet. They are basically holding it open while they gather some information, I guess.
We're supposed to hear back from them. They requested some verification that he was in treatment with us and that they were going to withdraw the warrant that he has out of their county. We haven't got confirmation on that yet, though.
Okay.
So at this point, I guess we still have that matter. Mr. Hill and I had basically discussed the possibility of, the state has had difficulty locating the complaining witness on the criminal matter, and we had discussed the possibility of a dismissal with a right to refile, but we also don't have the matter with Pickaway County completely closed yet.
Is there a case? I don't have a case on that.
Let me look at my file here.
The Rule 4. Do you have something?
CRA 25-653.
That's not our case. Is he in Pickaway County? That's a Pickaway County case number or a Lawrence case number with us?
The paper I'm looking at is in the Lawrence County Municipal Court, Chesapeake, Ohio, Criminal Rule 4 hearing, and it says CRA 25-631.
631.
Did I say the wrong number? I apologize.
That's okay.
You said 653.
I don't know where I even got that. I'm looking, I don't see that on this form anywhere.
It is on.
Just hasn't been updated as far as the court date on. It was last updated October 6th.
And he's still in treatment with the counseling center?
That's correct, Your Honor.
Well, if you want to leave it pending so that he can continue with treatment.
I think that's what we probably need to do for the moment until the warrant's withdrawn, and they.
Come back in a month or?
Yeah, I think that's probably reasonable. Let me take a look at my calendar. I've got a lot in January.
The 12th is actually a good day if you want to do that, if you're available.
Just a second, I'm having trouble with my calendar here. I am available the 12th, Your Honor.
January 12th will be the next hearing for Mr. Asari, if you can put that Rule 4 on that thing.
You don't have a file.
I do not have the file. Well, wait a minute. I think I do have the file, it's just another case number on.
This wasn't on the docket.
Yes.
This number wasn't.
It is in the same folder. 25-631.
State of Ohio versus Shannon Estep, case number CRA 25606.
Yeah, January 20th.
They're both shoot.
12th, January 12th, sorry.
Mr. Steyer's case, preliminary hearing.
Miss Estep, since we were here last, has completed inpatient treatment at OBP. Here we go. I have the certificate to present to the court. This is a copy. And RRS is where you signed up. And she signed up to continue with outpatient treatment at RRS.
Is this my copy you keep?
Yeah, that's your copy to keep.
Your Honor, Ms. Estep has not been in yet to assess. She was scheduled for next week. She has a mental health assessment on the 15th, nurse practitioner on the 16th, and SUD assessment on the 18th.
Okay, I think we need to, because this only arose in September, so I think we need
Yeah.
to keep monitoring her.
I've also,
And since she'll be starting with RRS now, and so I'd say a month or maybe a little done pretty well up to this point, so we make it 6 weeks or so.
Your Honor.
About the 26th or 30th of January.
The 30th I'm available, the 26th I have a jury trial.
Okay, we'll do January 30th.
So write that down.
Next hearing.
Okay. Yeah, and she, when you started, you may recall, she was on, well, and remains on methadone. However, she just advised that she had been reducing her dose.
What's your dosage now?
It's down to 140.
Okay. Keep working on that.
Thank you.
Thank you.
Thank you, Your Honor.
Good job.
Thank you.
State of Ohio versus Shelby Frazier, case number TRC 252357, A, B, and C. Shelby Frazier.
Ms. Frazier contacted me this morning, okay, there she is. She contacted me this morning with difficulty because of the weather and asked if I could get a continuance. I had suggested that rather than seeking continuance directly, if she could appear via video, that would be a better starting point. And so she has.
We have results from the urine yet?
And we don't.
The arresting officer actually came here this morning specifically because he had checked to find out, and we don't have results. And we're over time. There's been no time waivers. So I don't know what else there is to do. I think it's pretty clear. And I asked the trooper whether he thought that without the results that we could prove the case beyond a reasonable doubt, and he suggested that it was doubtful. So I don't know what else we can do but move to dismiss the case.
Well, she's got speed and expired tags.
Well, those are still worthy of going forward with, so hopefully.
I think those are also out of time.
Probably true. Okay, so you just want to nollie the whole thing?
I don't want to, but I don't think we have any other choice.
Case will be nollie due to time constraints.
Thank you, Your Honor. I'll contact you later and discuss this further.
Thank you.
State of Ohio versus Evan Holmes, case number TRC 252696, A and B. Evan Holmes.
Status case.
When I went out this morning and checked who had checked in at the station out there, Mr. Holmes had not checked in. However, I probably have a way to get a hold of him through family. So I would like to ask for a brief continuance if we could to either.
He was at Bethesda, this was back in October, so, and no one's here for Bethesda today, I don't believe. So he left, no one told me he left.
For that reason then, Your Honor, I'd like to ask for a continuance either the 19th or the 22nd if we could.
Your Honor, I apologize, I couldn't unmute.
Oh, there she is.
Evan Holmes is with Bethesda Services, and he's doing exceptionally well. We didn't transport our clients in because of weather.
Okay, so we'll just give him another day.
Well, the state is actually still looking for discovery on this matter. There's some information we've requested they haven't been able to provide quite yet, and so might go a little further since it's not a situation where he's just not shown up. I'd ask, with that in mind, if we could go to maybe the 29th of December.
Oh, I was gonna go in January.
I'm even better, that's even better, Your Honor. I have some days in January I'm unavailable, but doesn't look like they're not interfering with this court as much as the other court. I'm here the 5th.
Okay, January 5th will be the next hearing. Pre-trial, 10 o'clock.
Thank you, Your Honor.
Thank you.
State of Ohio versus Monique Houston or Huston, case number CRB 25708.
Your Honor, Ms. Houston also contacted me this morning with difficulty. She actually, her issue was not difficulty traveling. She has a daughter with special needs who's normally in school but wasn't able, or programming, wasn't able to be there today. So she asked for a continuance. I asked her to get onto the, actually I did ask her to get onto the Zoom call. I just heard about this at that point. I don't think I gave her the Zoom information. However, I've talked to the state about this, and this is a situation, it's a Walmart shoplifting. It has to do with items not being scanned. And on the video, you see Ms. Houston scanning various items, and another individual, Mr. Fortner, who was here earlier this week or last week. He was standing there with her. She walked away to get a bag of ice. Several minutes pass, she comes back with the bag of ice and scans it and puts it in the card, and he just hands her the credit card, and she goes ahead and pays. I think she thought he had scanned everything else, and he hadn't. And my understanding is he came in and pled guilty to the companion case last week, discussed this matter with the state, and they think Mr. Fortner may have been the more culpable party, and I think they're willing to dismiss this matter.
That's correct, Your Honor.
Case will be known.
State of Ohio versus Darrell Campbell, case number CRB 25751 ABNC, CRB 25739.
Mr. Steyer's case, Mr. Campbell went to TTC, and now he's in Cincinnati.
I knew he was somewhere new, but I didn't know where.
I've got laryngitis today. Sorry about that. He was accepted by University of Cincinnati psychiatric unit after his incident on Friday, the 5th, I believe.
And I've got like some conflicting information about that. I'm not really clear. Was there charges filed out of what happened there? Or?
There was.
Okay, and that's in Brown County?
In Brown County, yes.
Okay.
And we were attempting to get him accepted into the University of Cincinnati psychiatric unit and have the Brown County Police to transport. They refused and took him into custody.
Okay.
So now that University of Cincinnati has accepted him, they have allowed that. So he is at the University of Cincinnati.
So he did get transported?
He did, and they're assessing him currently.
Okay.
So there is.
I don't know to what extent they're going to communicate with me, because he's gotten there through a case that I'm not his attorney on.
I wonder if you can make contact with, I'm assuming he has court-appointed counsel.
Well, we'll soon at any rate, even if he doesn't yet. Are you going to know who that is?
I will be able to get that.
Tell you what I'm going to do is I'm going to give you my card.
Okay.
And ask that you contact me later, and we'll see what we can figure out. Because I think we're going to need to figure out what is happening with that, what he ends up charged with in Brown County. And then that'll affect how we. Make sure you write my handwriting. 634-529. That's my cell number. Just shoot me a text message. I feel like if he's actually now been officially taken in inpatient at a psychiatric hospital, I may need to file a suggestion of competency in an NGRI plea. However, I don't know that we need to necessarily let the official wheels go on that. So maybe there may be something for Mr. Hill and you and I to discuss outside of court.
Well, I think that we would all agree he needs some medical treatment for apparent psychiatric issues.
Yeah, I feel like he might be on a better track to getting that now than he would through the system, through the alternative system we usually use.
Your Honor, it looks like something was filed on November the 24th, defendant's plea of not guilty by reason of insanity and suggestion of mental incapacity.
Okay, I may have filed those then.
It's already been scanned.
Okay.
Okay.
Well, at this point then, I'm not gonna, unless council feels differently, I'm not gonna direct to Southern Ohio Forensics to do an evaluation. Since he's being evaluated at Cincinnati Psychiatric Hospital, I would suggest we wait and see what information we glean from that.
I think this might be one that we maybe give it a few weeks and see what his status is at that time.
2 weeks from that?
Let me take a look at my calendar. I've got a couple of things coming up here.
That's the...
Could we put this on the 5th? I'm coming in that day.
Mr. Hill?
5th of January, that's fine.
January 5th will be the next one. And if something comes up before then, we can deal with it.
Right.
If we need to. Mr. Wilson, thank you for the report.
Absolutely, thank you.
Sorry you had to sit here all day and give it.
That's fine. Thank you.
State of Ohio versus Robert Stifter, case number TRC 252722 A and B, and TRC 252303 A and B, CRB 25557.
This is Mr. Steyer's case for pretrial.
Your Honor, I've been provided with video on this matter. I need to review. I'm going to ask to continue this as well. The 5th doesn't look like today yet, so I was wondering if we could keep that date.
That's fine. January 5th will be the next hearing, pre-trial, 10 o'clock.
Thank you.
State of Ohio versus Rachel Markham, case number CRB 21715, Rachel Markham.
Rachel Markham is Mr. Steyer's case and set for pre-trial.
And Your Honor, when I looked this morning, Mr. Markham had not checked in and nobody has come forward. There is one up there that says iPhone that's not identified, but I don't know who that might be.
Rachel Markham, are you present on teleconference? Rachel Markham. Not hearing anything, so I will issue a benchmark for failure to appear today.
State of Ohio versus Richard Riggle, case number CRB 25668 A and B, CRB 25586 A and B.
Mr. Steyer's case set for pre-trial. Yes.
And Mr. Regal is at hometown recovery, so we've got a report coming forward.
Says there's still things to be worked on, but you're approaching the phase where you'll be able to go to work. Anything you want to say, sir?
Yes, actually, whenever I get back to work, I know I have a guilty plea on another case, and I'm going to be working to pay off my fines and my community service once I get access to that.
So, just kind of a question of what sort of time frame the court wants to look at to come back, Your Honor.
End of January.
End of January, I'm available the 30th.
That's fine.
Yeah.
Both of Mr. Riddle's cases in there are set for the 30th. 10 o'clock.
Thank you, Your Honor. Thank you.
State of Ohio, Kayla Harris, case number CRB 21209, CRB 211692.
Kayla Harris. Mr. Stires, please.
And Your Honor, you may recall earlier today, this was the issue that I had that prevented my continuing on with Mr. Harris.
Okay.
She contacted me this morning and said she was unable to get here today. I asked her to get on the Zoom call, and it looks like she may be there.
She is. Sorry.
And this is a review hearing matter, mostly, Your Honor. I think there's some old matters.
There is one case that's unresolved. 211692 is unresolved, and it is a TRD case number.
Oh, she's seeking her driver's license.
Yes, no driver's license.
Yeah, she's seeking her driver's license. She's made some progress in getting some of the fines that were blocking her paid off, but I don't think she's gotten the license yet. I think she may be at the point where she's gotten her learner's permit. Is that correct?
Yes.
She has her learner's permit, but she hasn't gotten the next step to an actual license. We were hoping to get her there because I think that one may be one that if it goes to the DMV could cause her further problems.
Okay, so you want to continue?
So we'd like a continuance, Your Honor.
Well, I'd say this is more appropriate for a month.
Well, that would put us to 12th of January, I'm here.
January 12th will be the next hearing.
January 12th?
Yes, ma'am.
Okay.
10 o'clock.
All right, thanks, sir.
You're welcome.
Thank you.
State of Ohio versus Sean Hall Burns Jr., case number CRB 25117.
Mr. Morford's case, except for pre-trial.
Judge, may I approach with a report?
Yes. It's a good report with negative screens. Are we to a point where we can resolve this one? This was his father was the complaining party, and it's been since, hasn't been a year yet, but it's been since February of last year.
Yeah, it looks to me like if that report indicates that he's made significant progress and is completing their program, we're okay with going ahead and dismiss it today.
Is senior here today?
My dad, he has a neck problem. He don't come out of the house much.
Okay.
And we've spoken with him.
But,
He's okay?
yeah, I think he
Yeah, I
also.
mean, his goal was to have his son complete the programming.
All right, I'm okay with no, I mean, this one just means it's dismissed. Now, you gotta keep doing the work.
Yeah.
I'm just not gonna oversee what you're doing anymore.
Okay.
So do it for yourself and your dad.
So I'm good?
You're good.
You're good.
Case is dismissed.
Thank you.
Good luck to you.
Thank you.
You're welcome. Good luck to you.
Thank you.
Thank you, Judge.
State of Ohio recalls Jacob Lee Lindsay, case number CRB 25788, A, B, and C.
All right, sir, are you Jacob L. Lindsay?
Yes, you are.
All right, Mr. Lindsay, Judge Capper, this is what's called an arraignment hearing for you. I think you got picked up today on a warrant on some charges. Have you received a copy of the charges? Okay, let's get you a copy of the charges. It's A, B, and C. 25788, A, B, and C. So you're being served a copy of the charges right now, and a summons. 788A, and well, before we go over the charges, let me tell you about your rights, because everybody else here has heard this 15 times today, so you haven't heard it at all. You have a right to remain silent. You don't have to say anything, but if you do make statements, everything we say here in the courtroom is being recorded, it's on the record, can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail. You have a right to make the state of Ohio prove any charges they file against you beyond a reasonable doubt. Do you understand those things?
Yes.
Okay, so we're going to go through the charges. You don't have to agree with them, but you need to understand them. The first one is 788A. It alleges that on December the 3rd of this year in Fayette Township, he knowingly, recklessly deprived an animal of necessary sustenance or confined the companion animal without supplying it during that confinement with sufficient quantities of good, wholesome food and water. That is filed under a statute that prohibits treatment, unduly treatment to companion animals during their confinement. So that's a first degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. 788B is the same charge, so it must be for a different animal. But the same day, December the 3rd, failure to properly provide food and water for an animal, also a first degree misdemeanor, and same case number, but the B section, so that indicates to me it's for a separate animal. Same thing with 788C, so it's the same date, just a different case number letter. So you have 3 charges of the same thing, failure to properly feed and water animals. Do you understand the charges?
Yes, Your Honor.
How do you wish to plead to these? You can plead not guilty, guilty, or no contest, and not guilty.
Not guilty.
Not guilty is the safest plea. Okay, I'll take your not guilty plea. Do you want a lawyer appointed? You have the right to be considered a court-appointed lawyer.
Please.
Do you work? You have
I
no
work.
You have no income?
No.
Okay, Mr. Morford, I'm going to appoint you to represent Mr. Lindsay. I'm entering a not guilty plea for you, sir. And you live Township Road 130, Chesapeake? Is that what your address?
Yeah.
Okay. What's the state's position on bond?
The state would request a $2,500 cash assurance.
Are all the animals picked up now?
Have you gotten the animals
We're
yet?
going to get them right now.
Doing it now? Okay. All right, so I'm going to order I believe I was told it was 6 additional animals to be picked up?
Yes, 6.
Okay, so I'm going to order that, I think they're pretty much already done that, but just so Mr. Lindsay knows that the animals are going to be picked up and he's not to interfere with that. I am going to give him an OR bond because I don't have any reason to believe he won't appear. So what that means is I'm letting you out on your signature that you promised to come to court. There's a preference for that now amongst the court. So if you don't show up, then the bond will be revoked. You have to pay the amount, and then probably a new bond will be set. And that's just happened a couple of cases here recently where people didn't show up or ordered them to pay the forfeit amount and post a new bond, and neither one of them could do it, so they wound up staying in jail. So if you don't want to stay in jail, come to court when you're supposed to. Okay, you understand that?
Yes.
I'll set your bond at $2,000. OR. Yes, and you'll need to go to the jail and be fingerprinted. Mr. Cooper will give you a form to take to the jail to get fingerprinted. So, what's your preference, since he's out on OR, what's your preference? Or I'm going to set it in January, I guess we should say it that way. I'm going to set it in January, and pretty much any date in January is okay. What's your preference, Mr. Morford? Well, it's got to be before the 12th, right?
Judge, I think I'm going to do a different procedure, so.
You're available now?
I'm available.
Okay.
Yes.
Well.
12 weekends at 12 or later.
12th's fine. You want to do the 12th?
Please.
January 12th is going to be the next hearing. January 12th at 10 o'clock, and you understand you have to come, you got to get yourself here.
I will.
January 12th at 10 o'clock, if you don't, you'll get a warrant, and then that's when you will go to jail for not appearing. Okay. Any questions?
Nope.
And someone, or if they haven't already, if you get back and the dogs are still there and someone comes to pick it up from the animal shelter, you're not to interfere with that.
What's it going to?
Okay. Just want to make that clear.
Wish I could meet you under better circumstances there.
Okay, that's fine. I'm here every Monday and Friday and lots of other times. So once your case is over, you can still come to court if you want and watch.
All right.
Thank you, Judge.
State of Ohio versus James Willis, case number CRA 2767. Your Honor, this has been picked up.
Okay, James Willis was subject to a warrant out of Boyd County. He's now being picked up by Boyd County. So this case will be dismissed.
State of Ohio versus Michael Fritz, case number CRA 2569 A and D, consulting civil, Your Honor.
And Michael Fritz is represented by Attorney Roger Smith. This is set for preliminary hearing, and it's my understanding he's in treatment now. Oh, thank you. It's a good record. How's the state want to proceed? He's been in treatment since May.
Well, I didn't see the report, but if it indicates that he's completed,
It doesn't say that.
we're happy to continue on, allow him to finish treatment as long as he's willing to waive time.
Judge, we'll waive time.
Okay. So I'm okay with this because he's doing so well consistently, is to go 2 months before we come back for another meeting. So around the 12th of February.
I've got a conflict, I'm here the 9th or...
Nice time.
Okay.
February 9th will be Mr. Fritz next time. 2926. Keep doing what you're doing, sir. Good job.
Thank you, sir.
You're welcome.
See you, Michael.
Yeah.
State of Ohio versus Johnny Lee Maynard, case number CRA 25577.
Mayor is represented by Mr. Smith, except for coming in.
I've just been here some onboards, take out the reports.
That's not real bad.
Yes, everything's going well, all right? So these are all the same, right? Yeah. May I approach, Judge?
Yes.
He's pretty good with that files. It's no way to skip it.
Very good report.
Way on your shoulders.
That's great.
Now, I had a note that there was a possibility you would be going to QRT. Is that still a possibility, or?
Megan is still here or not? Did you meet with Megan Dalrymple from
Was-
QRT? Did you meet with Megan Dalrymple from QRT?
Oh, yeah, I did.
Is that something you were interested in?
Not really, because she said that she didn't want to submit failure, so I didn't want
Okay.
to pursue that.
Okay.
He's gonna stay here?
He's going to stay here, Judge, yes, if we could just get a comeback date, keep him marking.
Let's do the end of January sometime.
January, I've got the 26th, then I have the trial. 126, is that good?
Yes, January 26th will be the next one. Okay, good job, Mr. Mayor.
26, that's your next one here, tell me what you're doing. January 26 at 10.
10 o'clock, January 26th.
It's like, you bring reports 10 o'clock.
Yeah.
Yeah, and then bring your reports with you. You'll see them, keep going.
State of Ohio versus Anthony Merritt, case number CRA 25400, CRA 25103, CRD 082201. Anthony Merritt.
This is Mr. Smith's case.
It is, Judge, I believe he has left treatment AMA. I've been told that, I'm not confirmed, but he's not here, so it would make sense.
All right, Mr. Merritt has failed to appear. There will be a warrant issued for failure.
State of Ohio records Joshua Harris, case number CRB 25741, CRB 21583, CRB 21289, CRB 21290, and CRB 21999, A and B.
Okay, well, we replaced Mr. Steyer with Mr. Smith because after Mr. Steyer got looking into it, he had a conflict with one of the complaining parties in a case, so let Mr. Smith take over. The issue is on bond. We got a new case and we got some old cases that had warrants outstanding for a while.
And Judge, I understand in speaking with Mr. Harris a little bit ago that he did turn himself in today. His father's here. He's just recovered from open heart surgery. He's pretty ill. I would ask, and I know it's been a while, there may be some other sanctions, but he be given an OR bond. He now has counsel. I will show up with him at the next hearing. He does not have any more contact with either Kayla Harris or Courtney Beater. Is that correct?
Yes, sir.
Mr. Hill.
I'm trying to make sense of it all here.
I guess it's better late than never.
With respect to the current charge that was just before the court, we're okay with an OR bond as long as we have a protection order. And we take those protection orders very seriously, so you gotta make sure that there's no contact.
No, that was denied. I have the paperwork anyways.
You have one out of this court.
This is a new one. It's from this
They
court,
sent
not
it
from
to,
another court.
oh, okay, I just got it in the mail.
That was a civil protection order, Judge.
Oh, okay, I'm sorry. I just didn't know what I was talking about then.
No, that's okay. Well, it's just apples and oranges.
Right.
With respect to these other ones, which we dug the files out, one of them's a cross-filing with Kayla Harris.
Yes.
And then one of them is a theft charge, 2 theft charges and a trespass. But it looks to me like he pled to those. I have a note that says he pled guilty, and this will be on the...
Yeah, I don't think he ever got sentenced though.
Yeah.
I think the file said sentencing, but it wasn't, there was no indication he was here.
Can we pull that up and check? 21,285.
What did I say? Guilty what?
285. There was a there's a CRA 21,289, sorry. 21,290 and 289 are the cases. Reading someone's handwriting. Sorry, it was 285, it was 289 and 290.
What is it?
What was the question?
Yeah.
Is there any sentencing on either one of those? 289,
No,
290?
there's no sentencing on any of them.
Okay. So those, he may have pled, but there's no sentencing done. And I had a note that July 26th, he pled to an M1, and it was set for sentencing in August, and it looks like he did not appear at that time. And then there was a traffic matter that's still pending, 21,999 A and B, for no operator's license and headlights out, that's still pending. And then there is also 21,583. That was the cross, I guess it was
Kayla Harris.
Kayla Harris was the alleged victim on domestic violence. So what's the state's position on those?
The state's going to need to have a little bit of time to refresh ourselves on this.
But I mean, do you want a bond now, or since he came?
Well, I mean, he came, I don't know what caused him to not be here for so long, or what caused him to not show up when he was supposed to back in 2021. I don't know if there's been an explanation given for that. But that would have an impact on how we felt about the bond now.
I abused pain medication, but I went to therapy, got treated. I've been sober for 2.5 years now. I was on the Vivitrol shot. I was scared to come and turn myself in then, or go to court, or go to jail and be withdrawal and sick. it was my stupidity because I was on pain pills, but that's old part of my life. That's why I'm here trying to get everything taken care of.
Mr. Hill.
I guess he came in on his own today. But these are going to have to be reckoned with.
Okay.
We're kind of serious back then.
I'm gonna give you a OR bond, but I'm gonna make it high, $5,000.
Thank you, sir.
Bond. So if you don't show up,
This one?
you're gonna have a lot of money to pay.
I'll be here, I promise.
So now we can set it,
Here?
Yes, Judge.
so it's gonna be in January,
I'm here the 5th, the 23rd, or the 26th.
5th is not bad.
I can do
Let's
that.
do that.
Who do I give this to, you? Him?
Just to him.
So everything for Mr. Harris is set for January 5th.
You got a piece of paper right there.
He will need to be fingerprinted.
Don't leave, I'll bring you a copy of this out to the lobby.
Mr. Cooper's gonna give you a form to take to the sheriff's office to get fingerprinted, and it'll be on the 25741.
So, but don't leave till you take that. To you? Yeah, to him first, then to me. Okay. There's your next hearing date. Call him before that date, so you get in before then.
Okay. And where do I go to for fingerprinting, Sheriff?
Sheriff's office, if you'll wait. Out here in the lobby, he'll bring you the form, you'll take the sheriff, go fingerprint you.
Thank you, sir.
You're welcome.
Thank you, Judge.
You're welcome.
State of Ohio versus Crisco Minton. CRA 25296, CRB 25297.
Lawyers in North Carolina, so I'm gonna stand in with you. Are you in treatment?
No, I just graduated.
Yeah. Your Honor, Ms. Minton was in treatment with Bethesda. She was in residential care, and she was supposed to continue an outpatient, but she has not been. I was informed that she had switched to a new, and she hasn't been in the screen or anything.
I'm doing outpatient with the new because I'm living in Milton with my parents. They're sick, and I just can't get down here like that. And new will let me drug screen in Milton, and I can do all my counseling and therapy over the phone and talk to the doctor on telehealth. They're working with me,
What
so.
I would want to
Okay,
do,
I'm
or
sorry.
to continue with that, is to do a screen today.
Okay.
Particularly,
I have no problem.
I know that they're what I would call a trusted provider. I won't say anything else other than that. I want to verify what your condition is, so go do your
Okay.
Come back.
State of Ohio versus Edith Ruth Ann Gregory, case number CRB 25315.
This is Mr. Smith's case. Okay, it is reviewed. This is the first review.
And then I said finish paying everything.
She's the defendant that's going before and been very argumentative with the court staff and presented some of them over the phone.
I'm not sure who.
Was Kim Meador you had a child with?
She's actually not, she's actually not, this is a review here.
Yeah, Judge, and I had represented her ex in a children's services case, so I would have to.
I think it was your brother that actually.
It could, okay, I recognize the name, but I would have a conflict, so I'll sit down.
So you're supposed to be going to anger management at RRF.
I've completed that, I have the paper here. And then I also have it on my phone with where I paid the fine last night.
Is this his to keep?
Yes.
I did explain to her when she called this morning, Your Honor, that I did not know if the payment would be processed until court was over because we were short-staffed and we usually pay the day before. We don't often get the process, though. If she didn't appear, she would have had a bench warrant.
Are you saying you paid the rest of it, or?
Yes, I have it here on my phone with where I've paid
She
it.
did pay the
Online.
It should be credited now.
Okay, so you're finished now, looks like. Well, I was told that you were rude. What do you say about that?
I'm sorry.
Okay, well, that's a good response. All right, your case is completed. Don't be rude anymore. We have long memories here, so you're free to go. Case is completed.
State of Ohio versus Kalen Wells, case number CRB 24657, A and B.
Your Honor, Michaela Wells just recently re-enrolled in outpatient services with Bethesda. She's been compliant with drug screens and services so far.
Okay, thank you for that report. How's everything at home?
It's going good. I go to court for I have my youngest two, and then I go to court for them on December 18th.
Here in Lawrence County?
Yeah.
Your Honor, I got a report from Children's Services this morning that says she is doing great, and they are in the process of reintegrating the children back into her household. I think you got 4 altogether?
Yeah, I have my youngest two living with me now.
Yeah, and the other 2 are on the way back to living with her, if all goes well, so we're hoping that happens. She
Now-
does have a hearing next week.
And you have a newer baby, right?
Yeah.
Okay. Born in February last year?
Yep.
How do you want to proceed?
We'd like to, we want to see it through to successful completion of the Children's Services case. And, you know, she pled guilty a long time ago, and we, at that time, said
A year ago.
that we would, we don't want her to go to jail over this, and we wouldn't ask for her to go to jail over this if she finishes her treatment, and she's well on her way, finishes her case plan.
I might suggest, I'm here next Friday, her Children's Services case is next Thursday, the 18th, maybe come back and see how that went, if she's been reunited, or we can go back further, but that's just a suggestion. Then I'm here January 5th.
I don't know that the case will be closed next week, but it's
January
getting
5th.
closer. Yeah, it's
January 5th.
All right, let's do the January 5th.
Okay.
January 5th, 10 o'clock.
State of Ohio versus Carissa Damon, case number TRC 25.
Your Honor, Ms. Cameron reached out to our counsel this morning saying that she couldn't make it in due to the weather, and I could write with here for her. She is currently compliant, but we are not where we need to be in order to be finished.
I'm sorry, I didn't know what the case number.
Case number is 25-709. Okay, well, she's not here, so I'm going to take that as a motion for a continuance on her part. Mr. Morford.
Please, Your Honor.
Has she been told this, that she's not where she needs to be?
I have a meeting, I just got the screenshot of the text message this morning, so I have a meeting, I'm going to schedule a meeting with her Tuesday of next week to have a conversation.
And you're going to deliver that message?
Do what?
You're going to deliver that message that she's not where she needs to be?
I am.
Okay, you can also deliver the message that the court wants her to appear on January the 12th. I think we've already said you, Mr. Mulford.
Yes, Judge.
That day. So 1 month, and that's because she didn't show up today. So I'll continue a month to January the 12th.
I'll take care of it. Thank you, Your Honor.
Thank you.
Thank you, Judge.
Your Honor, we have one case left, we're waiting on the urine screen.
Okay. I'm going to take a recess. We got one person doing a urine screen, and then we'll come back. She had counsel for her.
Yeah, each year, 12, John Royce.
Okay, it's Crystal Mint.
Yeah, I'm standing in for Sean over.
Okay.
Dad is really tells me, how did I got all my information?
Get on the swing.